item 31, my lord, is in listed for orders, but it should have been listed for motion, my lord.
Motion.
Motion. It may come on Friday, no? Monday. It may come out.
Item number 31. This matter has been wrongly listed in order columns. Let it be listed in motion column on 27th of October.
Some undertaking that may be continue, my lord.
So long it is not there,
My lord.
3 days, nothing will
No,
happen.
my lord.
Nothing will happen.
That may be continue,
Nothing.
but you otherwise execution is going on.
Interim order is there.
Order is there, man.
No, that was expired long back.
No, my lord. Only that I accede to my fear of my landless.
No, I'm agree. I
We'll
agree
see,
to,
nothing will happen till Monday. We'll see it on Monday.
May I please, your lordship? My lord, item number 4, my lord, today's listed CRP, my lord. Along with my lord, another CRP we have filed on same date, my lord. Both the matters supposed to be listed together, my lord, but same has not been listed. May I pray, my lord, both the CRP may be come up next Monday, my lord. The item number 4 along with this CRP, already numbered, my lord.
Heard Mr. P.K. Dekar, learned counsel for the petitioner, who submits that the petitioner has also filed another
CRP
civil revision petition bearing number
146 of 2025.
146/2025 and requested that this matter may be taken up along with the said civil revision petition. The prayer is allowed. List this matter along with the aforesaid civil revision petition on 27th October 2000.
May I please, your lordship. Lordship, I pray for listing of a matter, RSA 175 of 25, lordship. Lordship, may list it tomorrow, lordship. There is some emergency, lordship. Execution will be done on 24th, lordship.
Okay.
Published, lordship.
May I please, your lordship. Item number 14, your lordship. I am petitioner here. I am to file one additional affidavit, lordship. So any date may be fixed in the month of November, your lordship. A date may be fixed.
You are petitioner.
Yeah, lordship.
You have informed the other side.
No, lordship, you are not going to pass any other order, your lordship. Only adjournment I am seeking. I am filed the affidavit on.
But for
Affidavit is there.
adjournment, before mentioning, you have to inform the other side.
So they are caveator here in the matter.
We'll pass orders when the matter is called up.
Lordship.
May please, your lordship. Lordship, I am praying for listing of these two RSA, lordship. One is of 2017 and another one is of 2022, lordship.
Two RSS.
In the hearing column, lordship, we have filed early hearing petition that was also allowed by your lordship. Next week, any date?
Next week on a date to be fixed by registry.
Obliged.
May please, your lordship. Lordship, I am praying for listing MSC appeal number 439/17 on 27th and
What is the urgency?
amicable settlement. Both the parties agree for settlement. Lordship.
Next week on a date to be fixed by registry.
My lord, please. Item number 40, my lord, it's an appeal by IIT, my lord. IIT Guwahati, my lord. This is a land acquisition appeal. My connected appeal is not there before this honorable court today. My lord, let this both the appeals be taken together, my lord.
You have informed the other side.
Yes, my lord, I have been from the other side.
Heard Mr.
ABC.
A.B. Day, learned counsel for the appellant, learned counsel for the applicant/appellant, who prays that a connected land acquisition appeal bearing number
12375, filing number, my lord.
1, 2,
12375 of 2025, my lord.
with filing number 12375,
75
which has been filed by the
on
present applicant, may be taken up together. He submits that he has informed learned counsel for the respondents regarding his prayer, and they don't have any
my lord, they
objection.
said that they will be there. He said that I will be there. I have informed them, my lord, to be I have informed them that I am going to mention. She said that I will be there.
He's not there. We'll pass orders
My
when
lord,
the,
please, yes, my lord. One
when
hour.
the matter is called up.
But I have informed them, my lord. I have
Okay,
informed-
we wait for the order.
My pleasure. Lordship, I beg to mention for listing on RFL, Lordship. The matter was last sent 3/10/2024, Lordship, and next day is not given. Lordship. Any date, Lordship. Any convenient date. Lordship.
In the second week of November on a date to be fixed by registry.
Sir, please.
But, item number 36 or 37.
Yes.
I need some more time to file my reply on both the.
Have you informed the other side?
Yes, I've already taken the consent.
What is your name?
Am they?
Heard Miss M. D. Learned counsel for the respondent, who prays for some time for filing written objection against the interlocutory application filed by the petitioner in this case. She submits that, no, before that, and prays for some time for doing so. She submits that she has informed the learned counsel for the petitioner regarding her prayer and who has no objection to the same. Stop. The prayer is therefore allowed. Let this matter be listed accordingly after 3 weeks.
Yeah, please, your lordship. I beg to mention item number 2, your lordship, for adjournment, your lordship. Your lordship, the counsel for the petitioners are out of, not in Guwahati, your lordship,
Heard Miss
as they,
S.
as they.
S. Day, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel for the petitioner is out of station. The prayer is allowed. Let this matter be listed in the next week on a date to,
Out of November.
next week on a date to be fixed by registry.
Please, your lordship. I'd like to mention item number 8. I have taken the consent of the petitioner, your lordship, in this case.
Item number 8. What is your prayer?
It's just for 1 week, your honor.
Why?
Your honor, actually, my senior could not. be
What is
able
your
to-
name?
M. Sahu,
Heard Miss M. Sahu. You are for?
respondent.
Heard Miss M. Sahu, learned counsel for the respondent, who prays for an adjournment on the ground that conducting counsel for the respondent is out of station. He submits that she has informed the learned counsel for the petitioner regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed.
For listing of an MSc appeal number 130 of 2021. In this case, your honor, the respondent has expired. Substitution has already been filed, but 2 years, the matter has not been listed yet.
The second week of November.
Okay, your lordship.
May it please your lordship, I beg to mention one RSA lordship, it's a fresh matter. It may be listed in the motion column lordship. Tomorrow,
When have you filed?
lordship, on 5th, before the,
Next
Thank you,
week,
lordship.
next week on a
Yeah.
date, next week on a date to be fixed by registry.
lordship, there is another prayer lordship. I beg to mention one RSA to be listed in the orders column lordship.
Next week on a date to be fixed by registry.
May I please your lordship? Lordship, I beg to mention one CRP, my lordship. My lordship, I have filed the CRP on 17, my lordship. And my lordship, the execution is on the last day before vacation, my lordship, on 17. My lordship, the execution is there on the after tomorrow, on Friday, my lordship. So can this matter be taken up tomorrow, my lordship? It is with regard to delay.
Okay, tomorrow.
Oblige, my lordship, highly.
Morning, my lordship. Item number 29, kindly allow me after 1 week for adjournment.
Why?
My seniors are out of state on that requesting.
Who is for the other side? Not yet appeared.
Not yet appear. My lordship,
Heard
I-
Mr.
we
What
have,
is your name?
Arbora.
Heard Mr. Arbora, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed.
May I please, your lordship, I beg to mention a criminal IA, your lordship, for bail.
Why am I mentioning before this court?
Your lordship, the allotted court number 14, your lordship, I went there, but no one was there.
This court is taking civil roster. You have to mention before the senior court taking up criminal roster.
I Your Lordship, I beg to mention that in court number 14, it was allotted, but no one is there, Your Lordship. That is why.
There are many courts taking up criminal roster. You are before wrong court.
Your Lordship, I will
Go to the proper court.
oblige, Your Lordship.
May please, Lordship, item number 9. Adjourned today.
Item number,
9.
what is your prayer?
My conducting senior R. Sharma out of station.
You have informed the other side.
Yes,
What is your name?
D. Hazarika.
Heard Mr. D. Hajorika, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of Mr. R. Sharma, learned counsel for the petitioner. Stop. He submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same. Stop. Hence, the prayer is allowed.
May please, Your Lord. My lord, I pray for withdrawal of item number 41 of today's list, Your Lordship. There are two, actually, this CRP, it was dismissed for non-prosecuted. So you file a IA, Your Lordship. There I just mentioned the cause list, MC number 8 and IA 243, Your Lordship. So now the matter is amicably settled during the pendency of that prayer for restoration petition. So matter is amicably settled, so
You don't want to,
yeah,
don't want restoration.
yes, Your Lordship. So I have filed an IA for withdrawal
When?
recently. It is in the records already.
It is
IA
with
for,
the,
yes, I have filed a IA for withdrawal.
we'll take up the matter when it is called up. Today itself.
Oblige, Your Lordship.
Please, Your Lordship. Lordship, item number 21, my lord, with the instruction from the, from my client, my lord, I want to withdraw this matter, my lord. 21 item.
You inform your client
Yes, my lord.
by registered post with AD. And submit the notice, then only you will be allowed to withdraw. Not by mere oral submission. There is a procedure. Follow that procedure, you will be allowed to withdraw.
And another item number 51 of supplementary, my lord. With the consent of the other side, my lord.
Item number,
51, my lord. We have already consent, my lord. So my senior is now out of station, my lord. So matter may be fixed after 4 weeks, my lord.
what is your name?
RI Bhuya,
Your for?
petitioner.
Heard Mr. R.I. Bhuya, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. He submits that he has informed the learned counsel for respondent regarding his prayer for adjournment, who has no objection to the same. Stop. Hence, the prayer is allowed.
Your Lordship, I would like to mention item number 42. Senior is on leave, so matter may be fixed up after 1.
Senior is on
Leave.
leave. Okay. You have in
Mr. J. Kolika,
41,
42.
42. Learned. Heard Miss, what is your name?
S.
Heard Miss S. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel for the petitioner, namely Mr. G. Kalita, is unable to attend the court for some personal reasons. The prayer is allowed.
I think one.
POCSO, my lord, notice may go, my lord. And one more prayer, my lord. It was earlier rejected by your lordship, my lord. That order may be, I may be allowed to file an additional affidavit to bring on record, my lord.
Heard Mr. N.J. Dr. learned counsel for the petition. Also heard Mr. B. Sharma, learned additional public prosecutor. Let the, since offense under POXO Act is involved in this case, let the notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order. It is a charge sheeted case.
Charge
Records would be necessary or?
Maybe necessary because my lord, my new ground.
Oh, okay. Within 3 days from the date of this order, returnable on when?
7th November.
7th of November,
Right.
returnable on 7th of November. Let also the scanned copy of the trial court records be called for. The petition, learned counsel for the petitioner has sought leave of this court for filing an additional affidavit to bring on record the rejection order of the bail application which was filed earlier by the petitioner. The prayer is allowed. The petitioner may do so before the next date fixed, list accordingly.
I'm obliged.
And so let's say there is another matter, let's say item number 16. Charge sheeted matter, one status report was called for, which has not been issued.
16,
16.
16 Matapsa. What is your submission?
In the last occasion, let's say one status report was called for, let's say,
It is not called.
was called. It has not been received probably, let's say.
Okay. Then we'll call the matter in seriatim when the, you need not to remain present. We'll show your presence.
I'm obliged.
Impone order is a place. 76 minutes.
70,
76. Annexure 7, last annexure. By this order, this inordinate delay of 1053 days has been condoned, my lord, in submitting the appeal by the respondent. This ground for this condonation of delay was only putting blame on the conducting lawyer, that the lawyer was not informing about the date, etc. And nothing else, my lord. This there is no any other explanation also. It is a long delay of about 3 years, my lord. And it was but the learned trial court, while condoning the delay, let's get some findings, my lord, that can be looked into in page 79. The respondent also took the plea of illiteracy of the illiteracy of her client, of his client, that being illiterate person, he could not get the status of the case going on in this suit, and he was also not getting information, all those were taken. Then the learned court below gave the findings at page 79. In the page 79, first paragraph. Lordship got it.
yes.
During hearing, the learned counsel for the OP submitted the limitation to the to prefer an appeal against this is not the one.
No, on what ground the
80,
delay was
page
called?
80, page 80, my lord. Page 80, next page. First paragraph.
Yes.
This court does not know about the academic qualification of the plaintiff applicant. This court is of the opinion that intelligence of a person is not confined to literate people only. Intelligence has a wider meaning and it covers a wide range, irrespective of how many degree a person has or not. To be diligent, one need not be literate. To have constant watch over one's own case, one need not be that literate. All that is required is the interest and carefulness, and that is it. Filing a complaint against the conducting counsel before bar council, before association shows that the applicant was not satisfied with the work of his earlier counsel. The applicant, appellant, litigant always have a duty to be in constant touch with the conducting counsel to receive and
give proper instruction. The litigant cannot sit idle, leaving a briefing upon the conducting counsel and expecting that the counsel would inform them about the development of their case. Refund of any part of fee taken by the counsel does not imply any negligence on the part of the earlier counsel. The court's way to dispose of cases during the COVID-19 pandemic period, which minimum could fall in the court, as per instruction of the Honorable Guwahati High Court. Fixing the case for final hearing amidst COVID-19 pandemic by the court cannot be a fault on the part of the trial court, as cited by the appellant in the condonation petition. Next, the counting of delay period as 1091 minus 90 days equal to 1001 days is a mistake by the counsel, which mistake cannot be attributed to the applicant. The limitation period to prepare an appeal from a decree is 30 days under Article 116B of Limitation Act. The date of impugned judgment is 22/12/2020, 23/12/2020 was working day. Thereafter, there was a civil vacation in the court from 24/12/2020 till 1/1/21. The period from 24/12/2020 till 1/1/21 is to be excluded while counting the limitation period to prefer the appeal. This is also wrong on the part of the court below, my lord. This period cannot be excluded because it falls in the midway of the limitation period. So the appeal should have been filed within 29/1/21. The appeal is filed on 29/12/2023. There has been a delay of 1053 days. In fact, excluding the above earlier just eight days, which has been wrongly excluded, it will come to 1061 days. Anyway, my lord, there has been a delay of 1053 days as calculated by the court. The causes, as for example, complete dependence on the lawyer due to poor education of the applicant and non-information of the conducting counsel to the applicant about the case are highly possible. Equally, this court is of the opinion that the applicant was negligent towards the own case. The negligence has been given. The court was of the opinion that the applicant was quite negligent, and the delay is condoned with cost of provision payable to the DLS.
Where is the error?
Well,
Where is the error?
error is that the court itself came to the conclusion that the applicant was quite negligent.
Therefore, it imposed a cost of rupees 5,000.
Cost, that is, cost cannot be the only remedy, my lord, because it will. And education, regarding main, how the overlook the trial court overlook. Your lordship may look into the
Okay,
page 14, page 14.
we are issuing notice.
Page 14, my lord. He is a class 1 registered contractor. In the plan itself, it is stated. And that man has been considered to be a literate person. How it can be, my lord?
Heard Mr. A.C. Sharma, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioners Shri Hemanta Saikya and Shri Basanta Saikya, impugning the order dated 27/6/2025 passed by the Court of London, Additional District Judge number 5, Kamrup Metro, Assam, in Miss J case number 54/2023 in connection with title appeal number 55/2023, whereby delay of 1053 days was condoned in filing the title appeal number 55/2023. Learned counsel for the petitioner has submitted that the trial court erred in condoning the delay on the basis of contradictory observations made by it in the impugned order. He submits that though one of the cause for condoning delay was that the opposite party was regarded as an uneducated person. However, in the impugn order itself, an observation it has been stated that the opposite party is a class 1 contractor in PWD, which fact is ignored by the trial court while coming to the finding that the opposite party is an uneducated person. Moreover, the trial court also observed that, categorically observed that the applicant was negligent towards his own case, however, in spite of that, delay has been condoned. And thus the trial court erred in condoning the delay. Stop. The contentions raised by the learned counsel for the petitioners needs to be examined. Hence, let the notice be issued to the respondent.
Further proceeding with the statement.
The petitioner shall take steps for issuance of notice upon the respondent by speed post within 3 days from the date of this order, returnable on 21st of November. Stop. Further, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, further proceeding of the title appeal number 55/2023 pending before in the court of learned additional district judge number 5 Kamrup Metro shall remain stayed till next returnable date.
Item 5. Please, Your Lordship, my lord. The petitioner, my lord, he is a branch manager of SDFC, my lord, Ambari branch, my lord.
Raj,
On 2/6/2025, my lord, the ESIC recovery officer had served me a prohibitory order, my lord, which my lord will find at page 18. Page 18, my lord. ESIC has issued this prohibitory order to me, that is the branch manager SDFC, and it is dated 2/6/2025.
prohibiting what?
Page 18, my lord.
What was prohibited?
My lord, what was prohibited, my lord? This respondent number 1 and 2, they had defaulted in contributing their insurance, my lord. And therefore, the ESIC had issued this prohibitory order from, my lord, their accounts were supposed to be, that amount lying in their accounts was supposed to be given to the ESIC, my lord, under the ESIC Act. So that is what the prohibitory order they had issued. Now, my lord, if your lordship kindly sees the page number 19 at the top, my lord, page number 19, and in terms of this prohibitory order, the amount of rupees, numerically it is written, my lord, 12,67,749. However, when they write in the words, my lord, they write, my lord, rupees 20,67,749. So there was a discrepancy in the, my lord, numeric as well as the words. And therefore, since there was a confusion, my lord, as a branch manager, I did not proceed, my lord. Now, my lord, on 14/8/2025, since I did not, the prohibitory order was not complied, they issued me a show cause notice at page number 20, my lord. Page number 20, my lord. The ESIC served me a show cause notice stating why you have defaulted and they would take some action. So what
In show cause notice also same
my lord, same.
discrepancy is reflected.
Same discrepancy, my lord, even in the show cause notice, my lord.
Yes.
Now, my lord, when under pressure, we had, my lord, prepared the demand draft in favor of the, my lord, ESIC corporation. And we submitted the same to the respondent number 5, which was duly received.
And on, my lord, 2/9/2025, we received summon to our utter shock, which your lordship will find at page 25, my lord. Page 25, we received this notice, my lord, summon from the ESIC code, my lord, to Sri Amarjyoti Das, branch manager, SDFC. And if your lordship skips to the third paragraph, my lord, the court got order to issue notice why a contempt proceeding should not be initiated against you and direct you to remit immediately rupees so and so on the receipt of this notice, along with the order passed by this honorable court on 28/8/2025. Now, once this order came to our knowledge, my lord, we procured the papers of the connected contempt proceeding. And that contempt proceeding, my lord, will find in the page number 20 and page number 29, and that order of impugn order, my lord, will find at page 27. In fact, it starts at 26. ESIC code, my lord.
Page number?
Page 26, my lord. Before the Employees Insurance Code, Guwahati at the top, my lord, page 26, and order, my lord, will find at page 27. And relevant portion, my lord, will find at the fifth paragraph, my lord. Also seen petition number 682/25.
Putul, contempts of court act. Yes.
Page
please
27, my lord. My lord will see also seen petition number 682 filed by the petitioner under section 12 of the Contempt of Court Act, 1971, read with Article 215 of the Constitution of India, praying to initiate a contempt proceeding against the respondent.
You're pleased that this is not maintainable.
Because, my lord, because if your lordship kindly takes up the act, my lord. My lord, if your lordship kindly takes up the act, my lord. Section 10 of the Contempt of Court Act, my lord. Section 10, my lord.
Yes.
Section 10 says, power of High Court to punish contempt of subordinate courts. Every High Court shall have and exercise the same jurisdiction, power and authority in accordance with the same procedure and practice in respect of contempt of the courts subordinate to it. It has an exercise in respect of the contempt of itself, provided that no High Court shall take cognizance of the contempt alleged to have been committed in respect of court subordinate to where such contempt is an offense punishable under IPC. Now, my lord, this section 10 has been interpreted by a coordinate bench of this honorable court. This is a recent judgment, my lord. Coordinate bench. And section 10 has been interpreted to mean that only the High Courts have the exclusive jurisdiction. My lord, my lord, paragraph 7, my lord, operative portion, my lord. Paragraph 7, may I just read out? Upon hearing the parties, this court is of the opinion that the order dated 12/3/2024 of initiating contempt proceedings against the Circle Officer Dibrugarh East Revenue Circle Dibrugarh as well as the defendants number 4 and 5 is required to be interfered with inasmuch as the same were done and off date and also without issuing notice to them in respect of the initiation of contempt. Apart from that, a bare perusal of the section 10 of the Contempt of Court Act 1971, it is seen that in respect to any disobedience of an order passed by the learned trial court or subordinate court, it is the High Court who has the exclusive jurisdiction. So, my lord, for initiating contempt proceeding, it is only the High Court which has exclusive jurisdiction under section 10. Therefore, my lord, with deepest respect, my lord, the learned trial court below could not have initiated the proceedings against me. That is number one, my lord. And number two, my lord, this order was never communicated to us. Even, my lord, if we assume that there was jurisdiction, your lordship will see
what you are impugning in this case.
My lord, that impugn order, my lord, will find at page 27, my lord. Page 27.
This order you are impugning.
They have issued notice under contempt proceeding to me.
Okay.
Page 27, they say the petition number 682, my lord, sixth paragraph from the top, my lord, page 27. Also seen petition number 682 filed by the petitioner under section 12 of the Contempt of Court Act. And they've issued notice to me at page 28, my lord. This is the order which has been impugned. Therefore, my lord, all I am praying at this stage, your lordship will issue notice, but the proceedings, prima facie being without jurisdiction, needs to be stayed, my lord.
Proceedings of the miss case.
Of the miss case, my lord.
Yes.
This contempt case.
You are appearing for?
Lordships, I am appearing for the ESIC respondents
3 and 5, 3, 4 and 5.
In fact, we are also being wrongly being summoned under the contempt section.
Heard. Mr. What is your name?
A.K. Barua, my lord.
Heard Mr. A.K. Barua, learned counsel for the petitioner. Also heard Miss, what is your name?
I have
Eh.
been instructed to appear and file the Wakalatnama and the due course.
A. Neok. Learned,
Respondents.
learned counsel for
3, 4, and 5.
respondent number 3, 4, and 5, who submits that she has been instructed by the respondent number 3, 4, and 5 to appear in this case and seeks leave of the, and submits that she would be filing Wakalatnama very soon.
Initially, because I have received a copy, but however, because I have recused myself from this case, and my learned friend is appearing.
I'm also in the.
Standing counsel.
Standing. P. Neok.
A new.
A. Neok, Commandant Standing Council. Baki kya rakhi ho? This application under Article 227 of the Constitution of India has been filed by the petitioner Shri Amarjyoti Das, impugning the order dated 28/8/2025 passed by the learned Employees Insurance. Who passed this order? Commissioner?
Employees Insurance Court, my lord.
Employees Insurance Court in Miss case number 11/2025 in connection with ESI case number 3/2025, whereby show cause notice was issued to the petitioners under section 12 of the Contempt of Courts Act 1971. Read with Article 215 of the Constitution of India. Learned counsel for the petitioner has submitted that the Miss case number 11/2025 was registered on the basis of an application filed on the basis of a petition bearing number 682/2025, which was filed by the present respondent number 1 before the ESI court in connection with ESI case number 3/2025, praying for initiating contempt proceeding against the respondents within bracket present petitioner for what non-compliance? For
non-compliance of order dated, my lord, 2/8/2025, page 48, my lord.
Or non-compliance of order dated 2/8/2025 passed in
My lord, ESI case number 3/2025.
Passed in ESI case number 3/2025. Stop. Learned counsel for the petitioner submits that the initiation of contempt proceeding by the ESI court is an apparent violation of the provisions of Section 10 of the Contempts of Court Act, which bestow exclusive jurisdiction to initiate contempt in connection with any matter connected with subordinate court on High Court exclusive, High Court only. Stop. Learned counsel for the respondent number 3, 4, and 5 also makes similar submissions. Stop. Issue notice to the respondent since Ms. A. Neog, Learned Standing Counsel ESI, has already appeared for respondent number 3, 4, and 5. No formal notice need to be issued to the said respondent. However, Learned counsel for the petitioner is directed to furnish the copy of revision petition along with annexures to the learned counsel for respondent number 3, 4, and 5. Stop. As regards respondent number 1 and 2, the petitioner shall take steps for issuance of notice upon the said respondent within 3 days from the date of this order by speed post, returnable on 25th of November. In the meanwhile, as apparently there is an embargo in section 10 of the Contempts of Court Act in initiating the contempt proceeding by a subordinate court, further proceedings of Miss case number 11/2025 in connection with ESI case number 3/2025 is hereby stayed till next returnable date.
DPO.
Item 47 from supplementary.
May I please?
Yes.
My lord, I am before your lordship, the petitioner third party man. In the execution proceeding, I am in possession of the suit land matter. So, my lord, the respondent herein, my lord, the predecessors of the respondent, my lord, filed title suit 55 of 1996. In this suit, my lord, I have not been impeded as a party. I have not been impeded as a party. Suit was dismissed, my lord. Against this dismissal, the respondent filed title appeal, first appeal, that was allowed by the learned civil judge. Against this, my lord, some of the respondent of the first appellate court preferred regular second appeal, my lord. That has been, my lord, affirmed by the judgment and decree passed by the learned civil judge. Of the first
The first title appeal number was?
title appeal number, my lord, 38, my lord. 1 second.
38 of 99. RSA number?
38 of 1999.
RSA number?
RSA, my lord. RSA number, my lord, 96 of 2002. Judgment and order, my lord, 19/12/2013.
Yes.
And after that, my lord, the decree holder filed title execution case. My lord, page 117, my lord. This is the execution application.
Thereafter?
In that execution proceeding also, my name is not there. I am totally, my lord, third party petitioner in possession of the land.
Okay.
In quid.
Thereafter what happened?
My lord, thereafter, I have filed a title suit in the learned trial court.
Why separate title suits?
It's a separate title suit, my lord. That is at page 124, annexure 6. Annexure 6, my lord.
Page number?
Page number 124, my lord. Annexure 6.
title suit number 326 of 2022, my lord. In that suit, my lord, I have filed, my lord, it for, my lord, cancellation of sale deed number 1203 dated 22/6/1993. And that suit, my lord, was pending before the learned trial court. Subsequently, my lord, that title suit has been dismissed for default by order dated 2/8/2024, Annexure 7, page 131.
Yes, thereafter,
Thereafter, my lord, I have filed, my lord, one application, my lord. Annexure 8, page 133. Order 9, Rule 4, my lord. Under Order 9, Rule 4 of the CPC. For restoration of the suit.
yes, thereafter,
Thereafter, my lord, I have also filed an application, my lord. Application Annexure 9, page 136, my lord, under Order 29, under Order 21, Rule 29, read with Section 151 of the Code of Civil Procedure, my lord, for stay of the suit,
stay of the,
for stay of the title execution, my lord. For stay of the title execution. And my lord, I want to take your lordship, Annexure 10, page 142, my lord.
who is in possession?
I am in possession of the suit land, my lord. A portion, my lord, not entire land. Of DAG number 233, Patta number 77.
Okay, which order you are impugning?
My lord, impugn order is, your lordship will find at page, my lord, Annexure 12, page 152, passed by the learned Munshi, my lord, Civil Judge Junior Division number 1, Qatar at Silchar.
This application at page 142. You have filed under what provision?
Dear, my lord, this has been registered at Miskis, my lord,
No,
190.
that is not my question.
Lordship.
What is the provision under which you have filed this application?
That has not been mentioned in this application, my lord. That has been.
Then what happened? Where is the impugn order? Where is the impugn order?
So, my lord, impugn order is, my lord, 100 and, my lord, 152, my lord, Annexure 12. Passed by the learned Civil Judge Junior Division number 1, my lord. Order dated, my lord, 10/9/2025.
This order has been passed by executing court.
Yes, my lord. Entitled execution case number 29 of 2015.
On your application.
On your, without deciding, my lord.
Why it should decide when you are unaware? You are not sure under what provision you are filing this
No,
application.
my lord, annexure for restoration of the suit, Annexure 7, that has also not been disposed of.
That is a different matter.
My lord.
That is not, in the execution case, you have not filed any application under Order 21 Rule 97. You could have filed if you are in possession.
My application.
Your application
So my,
at page 142 was for
my lord, 142, my
or
lord, prayer was, my lord,
staying of the execution proceeding.
suspend the proceeding of the instant title execution proceeding until and unless the miss case number 192 of 2024 and miss case number 193 of 2024 arising out of title suit number 326, which has been filed by the present petitioner before your lordship. For this, my lord, I have filed this. Is final till the finalization of, my lord, the suit, title suit 326 of 2022, that I, my lord, I filed this application before the learned trial.
No. It appears that executing court has rightly rejected your application. Where is the error? You have not approached the executing court under order 21 rule 97. You could have done so if you have any right.
I have filed, my lord, order 21 rule 29 man, for stay of the execution proceeding. I have filed this petition. That has not been disposed of, and restoration of the suit, my lord, which I filed by the present petitioner.
Order 21 rule 29 application, where have you filed? Before which court?
Before the same court, my lord, before the learned civil judge junior division, who have passed the impending order.
Thereafter, why you have filed this application
Thereafter, my lord,
that is pending?
my lord, thereafter, the Nazir, my lord, though I have not mentioned my instruction, Nazir went to the place, my lord, found that I am in possession of the suit land, apartment of the suit land, and came back, my lord. And the next date, which has been, my lord, fixed on 29 of this month, my lord, your lordship will find 155 page, my lord. Paragraph 7, my lord, of the impending order. During the pendency of the, may I read, my lord?
Now you read order 21 rule 29.
My lord, order 21, rule 29, stay of execution, pending suit between decree holder and judgment debtor. Where a suit is pending in any court against the holder of a decree of such court, or for a decree which is being executed by such court, on the part of the person against whom the decree was passed, the court may, on such term as to security or otherwise, as it think fit, stay execution of the decree until the pending suit has been decided. Provided that if the decree is one of the payment of money, the court shall, if it grants stay without requiring security, records the reason for doing so. It is not applicable, provided proviso is not applicable to my case, my.
Order 21 rule 29 may not be applicable in your case. You are not the judgment debtor.
I am the judgment debtor, my lord. I'm
You are a third party.
Yes. Yes.
So appropriate course for you would have been under order 21 rule 97. And therefore court has correctly rejected your prayer.
Court, learned court has, my lord, rejected, saying that no case is pending, no suit is pending till date.
That is,
Though
that
al-
observation is also right observation.
That although the title suit is pending, but not dismissed for default. I am,
So that is also, where is the fault in
my,
that
my
observation?
question is that my prayer before your lordship would be that
They got the decree after a prolonged litigation.
if that
You file a suit, a different suit, and remain absent. And thereafter, by mere filing a restoration application, you want the decree to be not executed.
No, degree for the one, degree holder may.
Otherwise also,
Degree holder,
Article 227 interference
lordship,
requires, where is the error? I don't see any error in the,
my
you
prayer,
approach the trial court, approach the executing court by filing appropriate application under.
my lord, my limited prayer before your lordship would be the holder of the decree, my lord. He may execute the decree, but I am in separate possession of the suit land, my lord. That is my 233 dak. A portion, my lord. He may execute his decree. That is,
If you have any right over that land,
I am in, yes, I am in possession, my lord. Possessory right, my lord. Possessory right can be protected, my lord.
then you have to approach the executing court under proper provision. You have not approached, done so. By merely filing a separate suit, that too got dismissed. You cannot prevent execution.
My lord, my prayer would be that although there is a petition for restoration of the suit, that has not been taken into consideration by the learned trial court, my lord, by the learned judge, my lord.
Rightly done so.
One thing, my lord, and that's an order 21 rule 29, my lord. That has also not been taken into consideration without mentioning, my lord, anything. So, my lord, possessory title can on position, only on position, my lord. Possessory title, it is principle of law that who has been in long continuous possession, my lord, of an immovable property can protect by same.
Chamber of dictation. I am dismissing your revision petition.
My lord, your lordship can give an opportunity, my lord, so that I can file an appropriate application.
You can file appropriate application before the executing court. That observation will be there. But this revision petition is dismissed. I'll dictate orders in chambers. You see the order tomorrow in the website.
My lord, one thing, the learned trial court at least would have applied the judicial mind, my lord, in restoration of the suit, my lord.
No, that I will address in my order. That your submission I will address.
Oblige you.
My lord, first of all, my lord, this matter actually ought to have come up for orders. It has come up for admission. Service, my lord, upon respondents. My lord, some of the respondents have not yet been served. Your lordship will kindly.
You are appearing for
I'm for the petition. Respondent
petitioner,
number 1 to
but
5,
in last order, your name has been.
my lord, it has been juxtaposed. In fact, my counterpart learned friend's name is also Chakravarti, but it has been reflected as D instead of B. He was appearing on the last occasion.
Okay, now you have to take steps.
My lord, I'll address on the office note. Your lordship kindly sees 1 to 5 is represented by my learned friend. In so far as respondents number 7, 8, 9, 13, 14, and 15 are concerned, they have been served. Now, so far 6 is concerned, he could not be served because he resides in Delhi. So I pray for taking fresh steps by registered post upon respondent number 6, my lord. Respondent number 10, it's written no such person has been found in that address. So we'll have to ascertain the present address and take fresh steps upon respondent number 10. And insofar respondent number 11 and 12 are concerned, they have expired. So we'll have to ascertain the names of the legal aids and take steps for substitution.
Okay, heard Mr. D. Chakravarti, learned counsel for the petitioner, also Miss A. Lala, learned counsel appearing for respondent number 1 to 5. Learned counsel for the petitioner has submitted that this case has been wrongly listed in admission column. It ought to have been listed in orders column as service on the respondents is still not yet complete. Stop. On perusal of the office note dated 8/10/2025, it appears that notice issued to respondent number 13, 14, and 15 have been received by respondent number 5. Hence, the notices issued to aforesaid respondent within bracket 13, 14, and 15 bracket close are held to be duly served. It also appears from the office note that respondent number 6 resides at Delhi and therefore notices could not be served on the said respondent. As regards no, the petitioner is therefore directed to take fresh steps against fresh steps for issuance of issuance of notice upon the respondent number 6 by speed post within 7 days from the date of this order. 7 days from the date of this order. Returnable after 4 weeks. It also appears from the office note that notices issued to respondent number 7 to 9 were duly served. Stop. It is therefore declared that the notices issued to respondent number 7 to 9 are duly served. Stop. As regards respondent number 10, the notice has returned without service as no such person was found at the given address. The petitioner is directed to take fresh steps for issuance of notice upon respondent number 10 by speed post within 7 days from the date of this order, returnable after 4 weeks. Stop. It also appears from the office note that respondent number 11 and 12 have been reported to have expired. Stop. Learned counsel for the petitioner seeks leave of the court to take appropriate steps for substituting the legal heirs of respondent number 11 and 12. The prayer is allowed. Same may be done before the next date fixed. List this matter after 4 weeks.
Instead of 4 weeks, can it be 6 weeks, madam?
List this matter after 6 weeks.
The returnable dates for the notices may be after 6 weeks, madam. The returnable date. That has been
I got instead of 4 weeks, returnable after 6 weeks. Not 4 weeks, I say 6 weeks. List this matter after 6 weeks.
7.
May I please, Your Lordship? Lordship may kindly adjourn the matter for the day, Lordship.
Why?
Lordship, Mr. Khushi, he have some difficulty today. His neighbor have expired and he have gone for the cremation ground, Lordship.
Heard. Miss
F. Ahmed.
F. Ahmed, learned counsel for the petitioner. None has appeared for respondent number 128. No, you are appearing.
For my, one for respondent number 1 to 8.
Mr. T.U. Laskar, learned counsel for the this also Mr. T.U. Laskar, learned counsel for respondent number 1 to 8. Learned counsel for the petitioner has sought for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. You have anything to say?
My lord, my instruction is that the case has been dismissed for default and subsequently, my lord, they have filed title appeal against the order passed by the learned civil judge.
Order
Lord.
to assemble.
And my lord, the present petitioner, my lord, present petitioner in this case, earlier filed, my lord, one civil revision petition for interlocutory.
Okay, we are
My lord,
giving a short date.
Your lordship,
Let them
we
take
have
instruction.
One.
instruction in this regard.
Considering the submissions made by learned counsel for the petitioner, we pray for adjournment of the law. Let this matter be listed in the first week of November on a date to be fixed by registry.
Deeply obliged.
Obliged.
Item 10.
Intern Bilakok Bahar Kane Sokini.
May I please, your lordship?
Thank you.
Your lordship, this is an miscellaneous first appeal, your lordship, against the Railway Claims Tribunal's judgment, your lordship, in original application number OA number 03/2024, judgment and order dated 31/2025, your lordship. Your lordship, this appeal has been filed under section 23 of the Railway Claims Tribunals Act, your lordship, 1987, your lordship, challenging the very judgment and order, your lordship, passed by the Railway Claims Tribunal, your lordship, in dismissing the claim application of the appellants, your lordship.
Whether any substantial question is required to be framed.
No, your
No.
lordship.
Heard Mr.
D.S. Decca, your lordship.
Heard Mr. T.S.
D.S. Decca, your lordship.
D.S. Deka. Learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the appellants impugning the judgment and order dated 31/2025 passed by the Railway Claims Tribunal Guwahati bench in OA number Roman 2 capital U dash 03/2024. What happened to the OA? It was dismissed,
Yes, your lordship.
whereby the said original application was dismissed by the Railway Claims Tribunal. Miss M. Fukon, sorry,
Fukon.
K. Fukon, London. You are appearing for you. Your
Yes, yes,
central
yes.
government council,
Yes, yes.
London Central Government Council appears for the sole respondent. The appeal is admitted. Let the records of appeal is admitted, stop. No formal notice need to be issued as Learned Central Government Council has already appeared for respondent. Stop. Let the records of the OA number 2U dash 3/2024 be called for from the Railway Claims Tribunal Guwahati bench. Release this matter after receipt of the trial court records.
Your lordship, I have a prayer, your lordship. On the last occasion, your lordship, there was none appearance, your lordship, because of non-reflection of my name, your lordship. Your lordship, may my name be reflected, your lordship.
This is item number 10.
Item number 10, your lordship.
The name of Mr. What is your name?
D.S. Decca, your lordship.
B.
D.
D.
For Delhi, your lordship.
D.S. Deka be reflected as engaged counsel for the appellant in the cause list henceforth.
Much obliged, your lordship.
Obliged, your lordship.
11. Made clean, your lord. My lord, the present appeal has been filed under section 23 of the Railway Claims Tribunal Act, and my lord, the petitioner is challenging the judgment. The claim was dismissed by the learned RCT, my lord.
Heard Mr. D. Rathi, learned counsel for the petitioner. Also heard Mr. La, I forgot your name. Sorry. G. Pegu, Learned Central Government Council, appearing for the sole respondent. This appeal under section 23 of the Railway Claims Tribunal has been preferred by the appellants, by the appellant Messrs. Mangal Murthy Vanijya, impugning the judgment and order dated 27/8/2025 passed by the Railway Claims Tribunal Guwahati bench in original application number within bracket Roman 3/GHY/16/2023 odd, whereby the said original application was dismissed. Issue notice to the respondent, since Mr. Pego, Learned Central Government Council, has already appeared for the respondent. No formal notice is required to be issued to the respondent. This appeal is admitted. Call for the records of the trial court from the concerned Railway Claims Tribunal. List this matter after receipt of the trial court records.
Much obliged.
Item 12.
Yeah, Peter. Okay, this matter will kindly be fixed on Tuesday, hearing day. My senior, Monta will argue this matter. Today, he's on legs of court number 1.
Which Tuesday?
This coming Tuesday.
There are many Tuesdays which are coming.
Next Tuesday. He's on
Heard Mr.
A. Borua.
A.
Borua.
A. Burwa, Learned Counsel for the petitioner. Also heard Mr.
W.
W.
W. Hawk on behalf of Mr. A. Sattar.
W.
Hawk.
Hawk, Learned Counsel appearing on behalf of Mr. A. Sattar, Learned Counsel for respondent number
1
and 2. Learned Counsel for the petitioner has sought for an adjournment as Learned Senior Counsel conducting Senior Counsel for the petitioner is on legs in a different court. The counsel for respondent does not oppose the prayer. Let this matter be listed on 28th of October.
Interim order.
Interim is there.
Yes.
The interim order shall continue till next day.
Much obliged.
Item 30.
May it please your lordship.
Yes.
Since the other side have not filed any objection, let the matter be fixed for hearing. It's in the admission stage.
You are not ready today.
And no, I'm ready, your lordship. I'm ready.
What is your submission? Other side.
That's it.
Are you ready for hearing?
See, because it's fixed for hearing.
No. What is the matter?
The matter deals with a claim of a land which is purchased by
No,
person
which order you are impugning?
violative of item, page number, operative or page number 57, your lordship,
Page number?
57. We have filed a petition for, since it is barred by law, the suit is barred by law.
Rejection.
A
Rejection of the claim.
Yes, your lord. Barred by law directly. In fact, not only claim, you cannot even purchase it. And there is a separate authority, forum is there. So let the matter be fixed for hearing, will
Okay. Heard Mr. A. Narzari, learned counsel for the petitioners. Also heard Miss, what is the name? S. Chaudhary, learned counsel for respondent. It is submitted at bar that this matter may be admitted for hearing and may be fixed for hearing on a next date. Stop. Considering the submissions made by learned counsel for the parties, this CRP within bracket IO is admitted for hearing. Let this matter be listed in the hearing column on
That will be after the 10th, your lordship, next month. Because I'll be out of station.
in the third week of November on a date to be fixed by legislature.
Highly obliged, your lordship.
Item 14.
May I please, your lordship? I'm praying for a short adjournment, your lordship. I have to file one additional affidavit in the matter, your lordship. So matter may be fixed in the third week of November, your lordship.
Okay.
Yes.
Possible matter may be heard. If necessity is there, then definitely lordship will consider it. This is his application. Definitely he has brought all document as required.
Some additional.
Is there any stay is operative
Yes, sir.
in this CRP?
Matter is very simple, lordship.
What is the matter?
At appeal stage, they are the plaintiff to the original suit. At appeal stage, they raise a question that the defendant number 6 to the original appeal is expired. And since the trial court passed decree on that question, that is why the judgment passed by trial court is nullity.
Yes,
What was the judgment?
We came to know
What
subsequently,
was
your
the
lordship.
judgment? Dismissal.
Yes. To dismiss, my counterclaim was allowed.
Okay.
The material is there, lordship.
What additional affidavit you intend to file?
Lordship, a certificate was issued by the Gao Pradhan, and Gao Pradhan stated before that court, your lordship, that she got the information from the son, but son is not examined by the court. And furthermore, we were not allowed to cross-examine the respondent number 6 here,
No,
as
no.
they brought before
Which
the
order
court.
you are impugning in this case?
Lordship, impugning order is the lordship, Annexer E, page number 95, your lordship.
What?
The appellant is represented by so and so, lordship. Today is date fixed for personal appearance of the respondent number 6 and Gao Pradhan, Srimati Devika Bora. Accordingly, respondent 6, Srimati Pratima Bora is present and state that she is the respondent number 6 in the present title appeal, arising out of title suit number so and so. In support of her identity and address, she submitted her voter ID, PAN card, Aadhaar card, and certificate issued by the Gao Pradhan of so and so, Puarpathar, Bailungao. That document have been perused. As per the voter ID card, her name is recorded as Pratima Bora with the address stated in village Manjora, PS Gorisagar, district Sibsagar. As per PAN card, her name is mentioned and as Pratima Bora.
No,
and
no,
her
your,
father name,
you, just a minute.
Lordship.
You filed an application on 24/6/2025.
Lordship.
That application is lordship will find Annexer D, page number 89.
What was the prayer?
Here, lordship will find prayer at page number 92. Here, prayer is like, lordship, please to declare the impugned judgment decree dated 31/12/24 and 2/1/25 respectively.
On
First,
what ground? That Pratima Bora expired.
expired.
Lordship.
But she appeared in the appellate stage.
Yes, lordship, not only appeared, she also filed counterclaim.
Lordship.
And they are the plaintiff in original suit. They implicate that Pratima
Let-
Bora as put
Let,
to this.
let me submit before the court, lordship, that we came to know later stage that she is died in the year 2003, your lordships. Then we made the application before the court, your lordships. It was not in our knowledge while have
No,
File
but
that
she
I
is
can-
alive. She is not dead.
Yes, Lordship, yes, Lordship.
She-
We are not allowed to cross-examine this Fatima Bora, your
And
Lordship.
case was
before the
filed
court.
in the year.
We made the
2007.
submission before the court, your Lordship. We are not allowed to cross-examine. Anyway, Lordship, I may be allowed to file an affidavit. So you may be, Lordship may be pleased to give me at least 2 weeks time, your Lordship. Otherwise, Lordships, I will be highly pressurized, Lordship. And they are no way being aggrieved by this filing the
No,
affidavit, your
what
Lordship.
is the error in the impugn order? There seems to be no error. You are seeking declaring a decree void on the ground of death of a
Death
person
of a person,
who is not dead, who is present before the appellate court.
Lordship.
Then where is the error?
But our contention is that she is dead, your Lordships. Gapura.
Still your
both the-
contention is that
both the
she is
person
dead.
are from same person. She is from Sibsagar district and that Fatima Bora is from Jorhat district, your Tiok Lordship. Jaji Tiok.
Oh, okay, let them file
Jaji
additional
Teo.
affidavit. Let us see.
If you also kindly peruse the plan. So suit was filed in the year 2007. And that judgment, trial court was passed after 17 years of trial. And if your lordship kindly peruse
No,
page number
in
50.
this case, no stay is operated.
No stay, your Lordship, nothing.
Stay is not operated.
No.
Otherwise, they are stopped, lordship. Under the purview of 115 of earlier evidence.
No, we'll consider your submission. Let heard Mr. S. Dasgupta, learned counsel for the petitioner. Also heard Mr. R. Ali, learned counsel for the respondents. Learned counsel for the petitioner praised for allowing the petitioner to file an additional affidavit to bring on record certain documents which are relevant for adjudication of the instant CRPIO. The prayer is allowed. Let this matter be listed. When will you file?
Third week of November, your Lordships. Matter may be fixed in any date, your Lordship.
22nd?
Obliged, Lordship.
No. 20 November.
20 November.
Let
Obliged,
this
Lordship.
matter be listed. on the 20.
This is an appeal for enhancement. But
Heard Mr. M. Khan, learned counsel for the petition, appellant. This appeal under section 273 of the Motor Vehicles Act 1988 has been filed by the appellant / claimants impugning the judgment and award dated 21/6/2025 passed by the Motor Accident Claims Tribunal, Bongaigaon in MAC case number 105/2020. The appellant is mainly aggrieved with the quantum of award given by the impugned judgment to the present appellants. Stop. This appeal is admitted. Let the records of the MAC case number 105/2020 be requisitioned from the concerned Motor Accident Claims Tribunal registry to take steps for requisitioning the aforesaid records. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
I think 48 from supplementary is.
May I please, Lordship? Actually, there is no merit in this revision application.
Lordship, papers are also.
Let
I'm
him
not on the
start.
record, Lordship.
No, I may be excused, Your Honor.
I'm for the M. Shetty, Lordship. He has some difficulties on today, Lordship.
A short date may be given, Your Honor.
Not-
Otherwise, trial court's entire proceeding is being halted in the name of this revision.
His stay is granted.
No stay is granted. Even then, it is only keeping it on necessary order like this. Since the days of 2024 September. Almost 1 year is over.
Now,
Now it is-
Mr.
BK Gogoi Lordship. on
BK
behalf of
Gogoi
MSF.
appearing on behalf, you are also engaged counsel in this case.
No, Lordship.
Appearing on behalf of Mr. M. Sethia, learned counsel for the petitioner. Also Mr. H. K. Sharma, learned counsel for the respondent. Learned counsel for the petitioner submits that prays for an adjournment on
Short
the-
date may be given next week.
on the ground of personal difficulty of conducting counsel for the petitioner. Considering the submissions, the prayer is allowed. Let this case be listed on 28th October.
Must oblige.
Oblige Lordship.
Act 16.
Sorry, Lordship, time being Lordship, HRS of the case.
No,
Time being.
no time being.
Good number one.
Status
on
report
next.
has come.
It's come, Lordship. It is in the green flag, Lordship.
What is the status?
Lordship, when the paper rejected by your Lordship, 6 PWs were examined, Lordship. Thereafter,
Out of
Lordship,
20, Lord.
but your Lordship has observed that there are some more independent witnesses who are yet to be examined. That is the specific finding of your Lordship. Now, Lordship, from the status report I have seen, Lordship, for some reasons, 2 PWs were present, but they could not be examined. And then the PO is also on leave, Lordship. And the next date, as per the status report.
This is a POXO case,
Yes, no, 302, Lordship.
302.
302.
Yes.
Lordship,
Now, Lordship, the case.
6 out of 20, Lordship, till today, not taken.
Now, Lordship, the matter was fixed on 22/10/25.
Lordship, kindly see the first order, Lordship.
No, Mr. Sharma, what is your submission?
My submission is, Lordship, as per Lordship's rejection order, Lordship, some more witnesses, independent witnesses are there who are yet to be examined. That is this
They
finding of-
have to be examined.
They have to be examined.
Lordship, last 10 months, Lordship, 6 months, not to be taken any exam, Lordship.
That is clear from the status report. So it is not the only the fault of the prosecution, Lordship. The PO was also on leave, Lordship. In any case, Lordship, direction may be issued to the concerned court, Lordship, that expeditiously at least the independent witnesses may be heard. Lordship. That direction will suffice.
Yes.
Lordship.
Any terms and conditions, Lordship, you will appear, Lordship. Out of 26 already taken. Reject order kindly sir
Lordship,
details.
they will have
Lordship,
to get over the
last order
finding of
time.
your Lordship.
Where is the rejection order?
Lordship will kindly come to page 34. The operative portion is at page 36, Lordship. Paragraph number 14.
Okay, let us take up it at
Yes.
2. At 2. Let his senior come. At 2.
Or it is.
Lordship, 2 minutes, 5 minutes after, Lordship.
Okay, after some time.
Court hearing under order 41 rule 2, item 17.
Well, the respondent filed a title suit in the trial court, my lord, that was dismissed. And thereafter appeal preferred and appeal is allowed, my lord. That is where it is the second appeal, my lord. And the substantial question is at page number 13, ma'am.
Page number?
13, 1-3.
What is the case facts?
My lord, fact is that it is plaintiff is in 17, there are 7, page number 17. My lord, the Assam Rajyik Vidyut Porishad purchased the suit land about 10 bigha something, my lord. And it was purchased in the year 1980. Thereafter, on this suit was filed in the year 2011 by the plaintiffs. But here, not all the portadors, but 2 plaintiffs stating that they have not sell the suit land. And the signatures are not their signatures. and they have not received the consideration amount. And that was the issue. And they prayed for that the sale did be declared null and void.
Cancellation of sale deed.
My lord,
Cancellation of sale deed.
cancellation of sale deed.
Okay.
But thing is that, my lord, this
Trial court dismissed the,
trial court allowed, dismissed the suit. Yes, my lord, that was the respondent. Trial court dismissed the suit, my lord, because it is the defendant has able to prove that the respondent has received all the consideration amount, my lord. And the certified copy of sale deed was produced because the original was deposited in the circle office for mutation. And the circle officer could not able to produce the certified, the original sale deed because original sale deed was deposited in the certified, in the circle office. Thereafter, the certified copy was called for, was produced, and that certified copy was proved by the calling upon the volume. And the TI register, which they allege that they have not put their signatures. But the TI register is also not able to produce by the registered office because they have furnished a report that the TI register is damaged on flood. Everything is something there, my lord, because
then what happened in the appellate court?
appellate court dismissed, allowed the appeal.
On what ground? It cancelled the
Cancel the sale deed.
sale deed.
Yes, my lord. Now the question is that while the appellate court allowed the appeal, my lord, the sale deed in the name of Assam Rajyik Vidyut Parishad, he was not made party. Again, the appeal memo which was filed by the appellant is not in the name of the present appellant, my lord. And that was corrected so motu by the appellate court without giving any notice or without hearing any on the point, my lord.
Now,
here,
what is the substantial question which you are proposing?
substantial page number 13. my
No,
lord.
no, before that, one more query.
Right.
On what ground the appellate court cancelled?
Appellate court cancel only because the all documents which were produced by the defendants, my lord, that were not considered because only holding that mere exhibit of document does not amount to proof of the document. But thing is that the defendant has not denied any documents. Specifically, they have admitted that the sale deed, everything, that this is the certified copy and these are the amount which received by the plaintiff. The consideration amount was received by the plaintiff, that is not denied, man. But the appellate court hold that the mere exhibit of documents does not amount to probability. That was the only ground. Here, Assam Rajyik Vidyut Parishad is, as per the law, my lord, is a government. ATCPC notice was not served, nor they were made party. Again, the Assam Power Generation Corporation, he was made party, but after amendment, my lord, by amending, Assam Power Generation Corporation is made party, but no copy is served, nor any.
No, these are not, no copies served, these are not substantial questions of law.
My lord.
These could have been addressed by the trial court or the first appellate court. Are these the,
He has not appeared, he has not given any opportunity.
what is the substantial question of law?
The accessory party APGCL is not bring in the court, my lord. Without, because it is after amendment, my lord. Your lordship will find page number 70, page 70. Page 70 is the plain, my lord. Your lordship will find here what is written in the marking that Assam Power Generation Corporation Limited only this much, my lord. Neither their address is there, nor he is to be represented by some director or that was not there. So he has not served a copy upon Assam Power Generation Corporation, my lord.
No,
Though it was
the
amended.
entity remains same, only name was changed.
My lord, but I have not given any opportunity to file the written statement, my lord.
The
Again, my lord, Assam Power Generation Corporation. There is no any averment made in the plan that the Assam Power Generation Corporation is the necessary party. No any averment is made, my lord.
so which substantial question of law you are raising?
My lord, these are the substantial question of
These
law.
are all are not substantial question of law. If you press for all, then your RSA will be dismissed.
My lord, this one, anticipation notice is necessary, my lord.
That is not a substantial, that is a settled law,
My lord.
that ATCPC notice has to go. This plea you have taken before the first appellate court. Have you taken this plea before the first appellate court?
The written statement, my lord. There I have taken this plea, my lord. All this plea were
And
taken.
this was addressed.
No, my lord. Nothing, these are wrongly, my lord, passed the order, my lord. The issues were wrongly decided. That's why the 5, my lord, substantial question number 5. Where are the findings of the learned first appellate court in respect of learned first appellate court in respect of issue number 1, 3, 4, 6, 7, and 8 are perverse for not considering the facts of legal cares of Dipu Majumdar or Dipu Majumdar as necessary party, as well as non-consideration of exhibit B's counterfolio of check, exhibit C, money receipt, exhibit D, hand receipt, as well as exhibit 1 to 32, land revenue receipts, my lord. These are not considered, my lord. These are exhibited without objection, my lord.
Yes. What do you have to say?
Ships in this case regarding sale of bill. So we have already contested the sale deed for cancellation and declaration the right title interest over the suit land. So here
In whose possession Suitland is presently?
Not my position, my lord.
In your position.
My lord.
here the defendant while and DW. So DW says that the plaintiff was in possession till 1980. And thereafter, subsequently, another, and in the year 2000, Lordship,
Okay. Okay. Heard Mr. D.C. Setyapakan, London, counsel for the appellant. Also heard Mr. What is your name?
A.L. Mandru.
A.L. Mandal. Learned counsel for, you are appearing for all the respondents.
All the rest.
Learned counsel for all the respondents. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants impugning the judgment and order dated 3/7/2025 and decree dated 11/7/2025 passed by the Court of London District Judge Moregaon in title appeal number 1/2023, whereby the where is it, the trial court trial court's judgment. What is the date of trial court's judgment? Reference.
25th day of October. And 2019. All-
After considering
25th.
the submissions made by learned counsel for both sides and going through the materials available on record, following substantial question of law is formulated in this appeal within inverted comma, whether the finding of the first appellate court in respect of issues number 1, 3, 4, 6, 7, and 8 are perverse inasmuch as it did not consider the fact that the legal heirs of Deepu Majumdar were not made parties. Stop. Moreover, the first appellate court did not consider Exhibit B, Exhibit C, Exhibit B within bracket counterfoil of check, Exhibit C money receipts, Exhibit D hand receipt, and Exhibit 1
One, it is I, my lord.
Exhibit I
I.
land revenue receipt, while arriving at conclusion in the aforesaid, with regard to the aforesaid issues. You are representing all the respondents.
Yes,
Means Mr. What is your name?
A.L. Mandal.
A.L.
Mandal.
A.L. Mandal, learned counsel for the respondents, has represented all the respondents. No formal notice need to be issued to the respondents. This appeal is admitted. Let the records of the trial court as well as that of first appellate court be requisitioned. Let requisition the registry to take steps for requisitioning the aforesaid records. List this matter after 4 weeks on receipt of the records, aforesaid records. After 4 weeks.
I is here, my. So
I is for what?
stay, my
Stay of what?
judgment of the first appellate court. Judgment and decree.
No, there will be no execution.
My lord, because they have got the decree, my lord, for cancellation, and they have already entered into my land, my lord, by breaking the boundary wall,
No, that is a different issue.
my lord.
But
No,
judge,
stays even, my lord. Otherwise, I will be prejudiced, my lord.
how you will be prejudiced?
My lord, they since my sale deed is cancelled, my lord, because I have no.
Is there any, you have any objection to stay, prayer for stay?
Yes,
I have filed.
I have objection.
You filed written objection.
I have already filed an as I heard, dear my lord, they have tried to enter into my campus,
That
my
is
lord.
a different issue.
My lord.
Heard Mr. D.C.C. Fokan, learned counsel for the applicant, also heard Mr. D. Munda,
A.L. Mandal.
A. N. Mandal, learned counsel for the respondents. This application under order 41 rule 5 has been filed by the applicant. Applicant paying for stay of the operation of impugned judgment and decree passed in Title Appeal number 1/2023 during the pendency of the connected RSA number 171/2025. Stop Learned Counsel for the respondent submits that he may be allowed to file a written objection against the prayer for stay. The prayer is allowed. Let this interlocutory application be listed again on when will you file?
My lord, interim may be passed, my lord, otherwise they will enter, my lord. Till then, intermediate order may be passed.
Entering is a day.
Interim order may be passed, otherwise they will enter, my lord. I have filed one FIR there, my lord. They have entered.
When will you file?
15 days time. will be granted.
Till then, one stay may be given because they have already made attempt, my lord.
10th of. No, you have to satisfy in cancellation of deeds, whether stay is necessary or not. The relief is only of cancellation of deed.
But they have entered, my lord.
That is a different issue. You are not praying for any injunction.
If the stay is given, my lord, injunction is not necessary. my lord.
10th of.
10.
10th of. We'll hear his objection, then we'll decide on stay.
My lord. The caveat is to be disposed of, I think.
As the respondents have appeared as learned counsel for the caveator has appeared in this case. The caveat stands disposed of.
Oblige.
Typing at 16. Can you see your lordship order dated 21 by page 34, earlier order?
Some witnesses are yet to be examined.
Not one was that till today, no, not a single further examination. Your lordship rejected on 21/5/25. And we have annexed that might have page 54. And about 1.5 years. Main informant examined, all the intermediate minor witnesses are examined. I have an extra copy also. Your lordship, page 35, the 35, 36. 36, page 12, paragraph 12, 14. Sixth independence already examined. And last examination one might have 16, 26, 3/25.
No, but the observation was after examination of 6 independent
That
witnesses.
6 examination already examined. Thereafter, not a single examined by the Lord. All are 6 already independent.
No,
including-
the observation was
No, that is-
remaining 6.
Maybe might have remaining, maybe your lordship might have meant that independent 6 witness to it. That already examined, not remaining might have been, out of 20, total 20 witnesses are there. And since 26,
325, not a single witness examined.
Paragraph 7, my lordship.
Yeah.
Para?
7 of the order. Page 35.
Please, sorry.
This is the submission of the petitioner made at the time of the bail lordship. Altogether, there are 20 witnesses.
Yes.
Out of them, 6 have been
Already examined.
including the informant and some of the relatives of the informant, as well as one independent witness. So, lordship, at that stage, one independent witness was
But if
examined.
your lordship see the charge
And
sheet,
then
my lord.
lordship will say paragraph 14, this is the finding of your lordship, that 6 more independent witnesses are yet to be examined. And lordship, if you go by the status report also, lordship will kindly say the green flag probably. Lordship. At this stage, I am praying lordship a direction may be issued to expeditiously dispose of the said independent witnesses, lordship, at the earliest.
For last 6 months, not a single minor examines, not a single witness examines.
You have records of the
No,
trial court.
that was not called for, lordship.
We may examine the nature of the witnesses.
Nature of
I have
it,
annexed
and the
6.
acquisition, if lordship kindly goes also, lordship, this heinous in nature, it has also been observed by your lordship. A girl was strangulated, lordship. She died of asphyxia as a result of manual strangulation, lordship. And her body was also disposed of, lordship, through in a pond, lordship. So offense is very serious, lordship. I can show from the record itself, lordship, from the available materials, lordship.
We'll give some time, fixed time for
Yeah.
examining the independent witnesses. Thereafter, you may approach.
Who are the independent matter? My information, I have already stated matter here. Except one matter informant, the rest are my neighbors, they are independent, that is not related one.
Then we will have to examine the case diary.
That your lordship. Records. Record 9.
Yes, what is to be done?
Lordship may dispose it of, lordship, with the direction to examine the independent witnesses expeditiously.
Idea also matter, your lordships. Your lordship direction after examining the 6 independent, that means matter you have to examine. Now about 5 months, 6 months has gone by.
Okay. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. M. Alamgir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This is for the second time the petitioner has approached this court seeking bail in connection with Sessions case number 28/2024 pending before the Court of Learned Additional Session Judge Rangya. His earlier application for bail was rejected on 21/5/2025 in bail application number 1327/2025, whereby it was observed that the petitioner may approach the court again after examination of remaining 6 independent witnesses. I have also perused the status report received from the Court of Learned Additional Sessions Judge within bracket FTC Kamrup Rangya. We stop on perusal of the status report. It appears that it has been reported that in the aforesaid sessions case, 8 independent witnesses are yet to be examined. Stop. Since the petitioner has been detained behind the bars since 18/5/2024. Stop. This court intends to go through the case diary to ascertain the nature of the ascertain the statement of witnesses identified as independent witnesses.
Kindly see order dated 22/9/25. Your lordship's order. Here it shows that scan copy already received. He took time to go through the point. Just 22/9/20.
Scan copy আছে?
Order, your order sheet it is there. Your lordship's order 22/9/25.
No, but scan copy is not there.
That is what it is written, my lord. Received.
That is regarding also the report. The office note-
Scan copy of the report,
Yes, regarding the report.
not the record. Let the scan copy of the trial court record as well as scan copy of the connected case diary be called for from the trial court. Let this case be listed again on
Yes, people. Check করেছে না নাই নাকি? But order shows that it is there.
4th of, no, it is not there. On
Order shows that the learned addition what who submit that he has not gone through the scanned copy of the records and seeks some time for going through the same before his submission.
That is his submission.
It means by the records are there anyway. Records call for registry or from the registry.
Let this case be listed again on 4th of November.
4th of November.
4th November.
Yes.
This appeal is preferred before your lordship against the impugned order of the learned civil judge senior division, who has affirmed the learned trial court's order by observing that the suit filed by the plaintiff are within the provisions of barred by order 2 rule 2 of CPC.
You were the plaintiff.
I was the plaintiff.
Your suit was dismissed.
Yes. Due to by applying the provisions of order 2 rule 2 of CPC, which restraining as per rule 2 order 2 rule 2 CPC contemplates that second suit on similar relief cannot be filed. But here in this case, the cause of action was completely different.
Now, what is the substantial question of law which you are proposing?
Your lordship will find on case record, my lord.
Where is the substantial question?
At last slide of it.
Where is the substantial question?
The last of the after certificate and after annexures it might be.
It has to be there in the memo of appeal.
Yes.
That is the provision. But in your memo of appeal, there is no substantial question.
We file actually in this type. Sometimes these are the next before the memo of appeal. Sometimes it.
No, you forget about the practice. Follow the law. Law says it has to be there in the memo of appeal. Then it has to be there in the memo of appeal.
Your lordship find it.
Page number?
It was not numbered actually. After certificate, it has been annexed.
What is the substantial question?
May I read out, my lord?
Yes, which one is the substantial question?
There are, I will press 1 to 4, my lord.
These are not substantial questions.
My lord, actually, if you lordship would go through the facts of the case, my lord, there was a
If
PDF.
we have to go into facts of the case,
Yes,
then
sir.
this is not a question of law.
Question of law arises from the facts of the case. So. on the
No,
fa-
you are not right. First, you have to state the substantial question of law, which would indicate on that apparently it is a question of law. You have to formulate 1908 has been filed by the appellants, impugning the judgment and order dated 10/4/2025, passed by learned Civil Judge Senior Division Baksa, Musalpur, entitled appeal number 3/2024. The appellants have stated, appellants have just has stated, have mentioned 5 proposed substantial question of law in separate sheets along with the memo of appeal. However, on perusal of the same, it appears that the said substantial question of law are not precisely stated as required under clause 3 of the section 100 of this CPC. Stop. Learned counsel for the appellant seeks leave of this court to submit precise substantial question of law and prays for some time for doing so. The prayer is allowed. When?
After 2 weeks.
Let this
Or 10 days,
case be listed again on
27 or 8.
11th of November.
Prior to that, I can do. In this month, I think.
4th of November.
Can it be filed through an affidavit or simply just as a draft?
You file in formal way, file it in a formal way.
Formal. Only taking with the case record.
From supplementary list.
Mid-page, your lordship. This appeal by the defendants, lordship. The substantial question of law I have formulated. Page 6, lordship.
Trial court
Trial
decreed
court
the suit.
decreed the suit.
Suit was for,
Right title, interest, partition and recovery of possession, lordship.
you are in possession.
Yes, lordship.
Okay.
We purchased the suit property from defendant number 4, lordship. In presence of witness, defendant number 5.
And
her father.
appellate court upheld the trial court's
Trial
order,
court judgment.
concurrent judgments.
Yes, lordship. Both the courts held that the sale was by a minor, lordship. On the minority was declared on the basis of a certificate, that is a provisional certificate.
Where is the substantial question of law?
Page 6, lordship. Three and 4, lordship. 3 regarding that birth certificate, lordship. It is held by both the courts that it is a provisional birth certificate exhibited in original, but plaintiff one in her statement stated that the certificate was not original, lordship. And I have gone through births and death registration act, lordship. There is no provision for issuance of provisional birth certificate, lordship.
No, please read number 3.
Whether the learned courts are justified in passing the impugned judgments and decree by ignoring the fact that the exhibit 3, that is the birth certificate of the pro forma defendant number 4, that is the vendor of the defendant numbers 1 to 3 has no evidentiary value in as much as a provisional birth certificate has no evidentiary value. Had it
So,
been a-
so the finding is perverse,
Yes. And number 4, Lordship, whether the judgment and decree passed by the learned courts require interference by this Honorable High Court for non-consideration of various provisions of the
no,
Indian
no,
registration.
various provision is not a precise substantial.
Registered sale.
The
deed
substantial question of law has to be very precise.
Lordship, there are registration of a sale deed, Lordship, it regards to there are several.
You have
provisions.
not stated that in your memo. of
Here, I will approve of the exact sections, Lordship. In fact, Lordship, the registered
No,
sale
but
deed
what is the
carries a
requirement
presumption.
under section clause 3?
60, Lordship, Registration Act,
No, Ms. Chaudhary,
Lordship.
we are not going into registration act. First, you have to overcome section 100 clause 3,
Lordship.
where you have to precisely state the substantial question of law. On bare reading of question number 4, it does not appear to be a substantial question.
Because we have purchased the suit land by a registered sale deed, Lordship.
The possession is still with you. Land is with you.
Yes, Lordship. For that, I have filed one stay application, Lordship.
Execution case has been filed.
No, Lordship. No number has been provided to me.
Which provision of registration act has been violated?
Lordship, registered sale deed carries with it a presumption that it was properly executed, Lordship.
We are framing only for question number 4.
3 is also important, Lordship, regarding birth certificate. But my entire case is dependent on the question that the sale deed was executed by dependent number 4, who was a minor at that relevant point of time. After issuance of notice, dependent number 4 and 5 did not understand.
Ms. R. Chaudhary, learned counsel for the appellant. This appeal under section, this regular second appeal under section 100, read with section 42, rule 1 of the Code of Civil Procedure 1908, has been filed by the appellants impugning the judgment and decree dated 29/8/2025, passed by the Court of Learned Civil Judge Senior Division, Dhubri, in title appeal number 21/2024, whereby it upheld the judgment and decree dated 31/7/2024, passed by the Court of Learned Civil Judge Junior Division, Dhubri, entitled suit number 137/2014. After considering the submissions made by learned counsel for the appellants, and after going through has no evidentiary value inasmuch as a provisional birth certificate has no evidentiary value, inverted comma clause. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable after 4 weeks.
Up to 5, respondent number 1 to 5, 6, 7, 8, my
I'm
learned
agreeing.
friend is it. Extra copy I will serve.
Since Miss D.D. Burman, learned additional senior government advocate, has appeared for respondent number
6, 7 and 8.
6, 7, and 8. No formal notice need to be issued to respondent number 6, 7, and 8. As regards interim, let them appear and let
Lordship
them,
may issue notice in my IA also, so that I can take
in,
step in.
in
both of
IA also same order.
them. And only Lordship,
I-
any other substantial question of law that liberty may be granted.
Law is there. You can press for any other substitute.
At the time of final hearing, respondent take an objection that there was no leave granted to you. At the
Leave is
time.
not required. 100 is very clear. Court can formulate any other substantial question of law at any time. If you can precisely state at any time you may pray for.
Lordship, that in IA Lordship, liberty may be granted if in the meantime execution proceeding has been initiated by them Lordship. I may be allowed to brought on record by an additional affidavit. As because I have not mentioned.
I same heard Miss R. Chaudhary, learned counsel for the applicant. Also heard Miss D.D. Burman, learned senior government advocate, appearing for respondent number 6, 7, and 8. This application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant / appellant praying for stay of the execution of the impugned judgment and decree passed by the Court of Learned Civil Justice Senior Division in title appeal number 21/2024. Stop. Issue notice to the opposite parties respondent. Since Ms. D.D. Burman has already appeared for respondent number 6, 7, and 8, no formal notice need to be issued against the said respondents. As regards other respondents, the applicant shall take steps for issuance of notice by speed post within 7 days from the date of this order, returnable after 4 weeks. Learned counsel for the applicant seeks leave of this court to bring on record whenever an execution case is filed by the opposite parties, the leave is granted, list according.
Item 50.
Item 50 is also by the defendants Lordship.
Concurrent
No,
finding.
Lordship, in this case, what happened, suit was decreed and we were not aware about the judgment of the trial court Lordship as because defendant number 2 in the meantime died, who was representing the case in favor of us Lordship. And thereafter, some dispute arose, their cousins Lordship. So in between them, thereafter, from the FIR only we came to know about the judgment. Then with an application for condonation of delay, title appeal was filed. That condonation was rejected by the first appellate court. So my substantial questions of law formulated in page 5. From the suit itself, it is found that in written statement, we have taken a ground that the suit of partition is bad for non-gender of necessary parties. That was rejected by the learned trial court on merit that ground. And
No. You have filed this RSA
against
against the dismissal of your condonation.
As per Lordship, 2005, 1 SCC 436. Lordship.
What is it?
Shyam Sundar Sharma.
What it
If
says?
condonation is rejected, then title appeal also Lordship dismissed automatically. Then
Therefore, second appeal lies.
Yes,
But in second appeal, the question would be, what would be the substantial question?
whether the causes shown by the appellants before the learned first appellate court in condonation application were sufficient or not, Lordship.
That is the only question.
Yes, Lordship. On merit, we normally put one,
No, on merit, we will not go. Suppose
Lordship.
it is found sufficient, it will remand back.
Yes,
And if it is not found sufficient,
Then it
your
will be
appeal will be dismissed. We cannot go into merit of the main case
Lordship.
because your appeal was not admitted.
No, Lordship. It was not.
So the question of law would have to revolve against the
Page-
delay condonation application only.
Yes, Lordship. Page 5, second substantial question of law.
That is also on the plea. That has to be on the ground of perversity.
Yes, Lordship, there were sufficient, Lordship, sufficient.
What is held in this judgment which you are relying?
It says if condonation is rejected, title appeal is also dismissed. So thereafter, it amounts to a decree.
Yes. So
So second appeal will be filed, Lordship.
second appeal lie, but there has to be a substantial question.
No, that aspect was not taken into consideration in this case. Paragraph 12, Lordship.
Read para 12.
That council placed reliance on the decision in Ratan Singh versus Vijaya Singh and others rendered by two learned judges of this court and pointed out that it was held therein that dismissal of an application for condonation of delay would not amount to a decree and therefore dismissal of an appeal as time barred was also not a decree. The decision was rendered in the context of Article 136 of the Limitation Act 1963 and in the light of the departure made from the previous position obtaining under Article 182 of the Limitation Act. But we must point out with respect that the decisions of this court in Messrs. Melaram and Sons and Shodhan Singh were not brought to the notice of their lordships. The principle laid down by a three-judge bench of this court in Messrs. Melaram and Sons and that stated in Shodhan Singh was thus not noticed and the view expressed by the two-judge bench cannot be accepted as laying down the correct law on the question. Of course, their lordship have stated that they are aware that some decisions of the high courts have taken the view that even rejecting an appeal on the ground that it was presented out of time is a decree within the definition of a decree obtaining in the court. Thereafter, noticing the decision of the Calcutta High Court above referred to, their lordships in conclusion apparently agree with the decision of the Calcutta High Court. Though the decision of the Privy Council in Nagendranath Dev versus Suresh Chandra Dev was referred to, it was not applied to the ground that it was based on Article 182 of the Limitation Act 1908 and there was a departure in the legal position in view of Article 136 of the Limitation Act. But with respect, we must point out that the decision really conflicts with the ratio of the decisions in Messrs. Mela and Sons and Shodhan Singh and another decision of this court rendered by two learned judges in Rani Chaudhary versus Lieutenant Colin Smith. The Rani Chaudhary was relied upon lordship and thereafter it was held that dismissal of condonation application will be amounts to be a decree.
No, I want to understand.
On merit, whether we can. formulate
Yes,
one substantial-
suppose you preferred in first appeal beyond the period of limitation.
Lordship.
You therefore preferred an application under, say, for condonation of delay. Delay was not condoned because sufficient ground was not found. So this apex court held that dismissal of an application for condoning the delay amounts to dismissal of the appeal itself. And it amounts to a decree. Therefore, second appeal lies. That is your submission.
Yes.
Assuming that second appeal lies, it would not automatically lie. You have to formulate a substantial question of law in dismissing the condonation of delay application.
So our first substantial question of law would be whether the reasons assigned by the appellant before the first appellate court were in spite of sufficient cause, were not considered.
No, unless you plead perversity, that the judgment, that is my tentative observation, that unless the appellate court's dismissal of your limited condonation of delay application is regarded as perverse, second appeal would not lie. So you have to show that it was perverse.
That was perverse, that my sufficient grounds were not taken into consideration.
That you have to
Then-
satisfy that it was perverse.
Lord-
Perversely your delay condonation application was rejected. Only then it will be admitted.
For that, Lordship, I have to read the condonation application, and I have filed the condonation application along with all the medical documents, Lordship. One of the appellant is 87 years old at the time of filing of the condonation applicants, our mother, Lordship. And one brother died in the year 2019. So all those medical documents we have annexed with the
No, you are not getting my point.
whether learned first appellate court considered my explanation or not.
No, mere consideration is not enough. It considered and it decided wrongly is not a substantial question of law. Substantial question of law would be if the decision is perverse, only then this court will interfere. You go through,
My case is that, Lordship, even in presence of sufficient reasons, the learned first appellate court purposely
then
decided
you
that-
have to satisfy what is perversity.
Lordship, in
Because
presence of
every wrong decision cannot be regarded as a perverse decision.
the causes which were shown by the appellants before the last learned.
You are ready today, then we'll take it up after lunch. But if you fail to satisfy that it is not perverse, then this will be going to be, I am going to dismiss this. I will not admit.
Then your Lordship may take it on some other day. I will satisfy with your.
You
some
come ready,
citation.
you come ready with citation
Yes, Lordship.
that how a point
Today,
of
only
point
this
of
whether-
limitation is to be dealt with when question of perversity is raised.
Condonation, there are several judgments says that it should be considered with liberal approach, Lordship.
No, but we are dealing a regular second appeal. So a regular second appeal gate is always closed. It will be open if substantial question of law you can show it.
Lordship.
And
Then on condonation, I will bring some judgment.
heard Miss R. Chaudhary, learned counsel for the appellant. This regular second appeal under section 100 of the Code of Civil Procedure has been filed by the appellants impugning the judgment and decree dated 16/6/2025 passed by the Court of Learned Additional District Judge number 5, Kamrup Metro in Miss J case number 70/2021 arising out of title appeal number 19/2021, whereby the prayer for condoning the delay in filing the aforesaid title appeal was rejected. Learned counsel for the appellant has submitted that since at the first appellate stage, the appeal was not admitted because the delay in preferring the said appeal was not condoned by the appellate court, first appellate court. The said rejection order may be treated as a decree, and therefore this regular second appeal is maintainable. On a pointed query by this court as to what would be the substantial question of law in this case, as same has to revolve only against the order passed in Miss Case number 70/2021. Stop. Learned Counsel for the appellant submits that if the first appellate court has dismissed the said Miss Case and declined to condone the delay in spite of the applicant showing sufficient cause for condoning the such delay, said rejection order may be regarded as a perverse order. She also submits that she may be given some time to produce some authority in support of submissions made by her. Prayer is allowed. When?
27, 28.
Let this matter be listed again on 28th of October.
28, 10. Obliged.
None appears for the applicant on call. Let this matter be listed again on 4th of November.
20. It is listed wrongly today in orders column lordship. It is already fixed for hearing lordship and it's the last order.
Heard Mr.
D. Dole lordship.
D. Dole, Learned Counsel for the appellants, who submits that the matter is ready for hearing and has been listed wrongly in the orders column. Stop. Let this matter be listed in the hearing column after 2 weeks.
That may be fixed lordship. I think so.
Hearing column in the 3rd week of November on a date to be fixed by registry.
21.
Your lordship, I want to withdraw this petition, my lord.
Why?
My lord, both the petitioners and respondent, my lord, already settled this matter, my lord.
Okay, heard Mr. What is your name?
L. Wajida, my lord.
Heard Miss L. Wazida, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw this instant revision petition on the ground that matter has already been settled between the parties amicably. Stop. Considering the submissions made by Learned Counsel, the prayer is allowed. This revision petition is dismissed on withdrawal.
Obliged.
Item 22.
Nothing matter will pass out for a time being, and this council is on legs.
Matter has come for, it should have come for another admission. Matter has come for orders. Should have come under heading admission.
Council came, Lordship.
Orders
No,
came,
we
my lord.
will fix it in admission column.
Yes.
Lordship, already TCR has come up, and in the orders list.
It should have come in admission column. Or hearing. Heard Mr. This is item number A.K. Purkayastha, the Learned Counsel for the petitioner. Also heard Mr.
S.A. Bhakti.
S.
A. Bhakti.
S.A. Bhakhtiar, Learned Counsel for the respondent. It is submitted at bar that this matter has been wrongly listed in orders column, comma, it should have been listed in the admission column. Stop. Let the
This is a date may be fixed also, otherwise the matter will keep on pending for a long time. After 15 November, any date, lordship, it will be convenient for us. Right, 15th of November.
Then document and fix the matter on 24th of November.
24th of November.
Master.
May I please your lordship?
Yes.
As per office note dated 8/5/2025, service upon the sole respondent is completed, my lordship.
Your lordship, I'm appearing for the respondent. The respondent has no objection regarding the transfer of the petition as paid by the petitioner.
Lordship, upon matter may be listed at admission hearing.
No, she is conceding we can dispose it of today.
Yes, your lordship. We have no objection. Matter be transferred.
What is to be transferred from where to where?
Your lordship, the case was filed by the respondent in Hailakandi court and the petitioner stays in Silchar. So due to the jurisdiction issue, the case was filed. So now the respondent has no objection if the case is done in the jurisdiction of the Silchar.
Silchar has jurisdiction or not?
Actually, the marriage was solemnized in Silchar.
Okay, so Silchar also has jurisdiction.
Yes, your lordship. Now they are saying since the petitioner cannot move from Silchar to Hailakandi for the process, so
Marriage was performed at Silchar.
yes, your lordship.
Okay. Heard, Mr. What is your name?
JP Boiso.
JB?
JP Boiso.
JP
Boiso.
Bosho, learned counsel for the petitioner. Also heard Miss
A Khashnobish.
A.
Khashnobish.
Khashnobish, learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure, 1908 has been filed by the petitioner, Srimati Sanchita Rani Roy, praying for transfer of title suit within wicked divorce. Case number 71/2024 from the Court of Learned District Judge Hailakandi to the Court of Learned Principal Judge Family Court Kachar Silchar. The aforesaid suit was filed by the respondent seeking divorce from the present petitioner. Learned counsel for the petitioner submits that since the court at learned counsel for the respondent submits that since the marriage between the petitioner and the respondent was performed at Silchar, the courts at Silchar also have jurisdiction to try the aforesaid case. She further submits that the respondent does not have any objection if the aforesaid title suit within bracket divorce case number 71/2024 is transferred from the Court of Learned District Judge Hailakandi to the Court of Learned Principal Judge to the Family Court Kachar Silchar. Stop. Considering the submissions made by learned counsel for both the parties, more particularly the concession, more particularly the fact that the respondent is not opposed to the prayer for transfer of the aforesaid case to the Family Court Kachar, this transfer application is allowed. The District Judge Hailakandi is directed to transfer the records of titles of divorce case number 71/2024 to the Court of Learned, to the Family Court Kachar. As both the parties are represented by their engaged counsel before this court, they are directed to appear before the Court of Learned, appear before the Family Court Kachar Silchar on 28th November 2025. Stop before the aforesaid date. Learned District Judge Hailakandi shall ensure that records of the aforesaid case reaches the Family Court Kachar Silchar in pursuant to the directions given herein above. This transfer petition is accordingly disposed of.
Deeply obliged, your lordship.
Item 24.
Here, my lord, I am appearing for the respondent opposite party. Here I want some time, 10 days time to file objection. Because it is not an executive decree, so the IA for stay is not maintainable. What is in this case, my lord?
You have filed an execution application.
No, I have filed for against my case. He is the counterclaimant defendant. If his claim was dismissed, his claim was for right title, interest and confirmation of possession and partition. His claim was dismissed. And against that claim, he filed an appeal. And that appeal also dismissed. Against my decree, he has not filed any first appeal.
It is composite bill, my lord, matter has been decided in both the way. They did not, loss of file,
So
bill.
this IA, what relief you are seeking?
I have for stay of the execution proceeding. I have.
Execution proceeding, you have-
I have for stay of the invoked judgment. and the
Judgment stay, there
appellate
is
court.
no provision
Appellate court.
in the order 41 rule 5. You can stay the execution of the impugned judgment. Judgment itself cannot be stayed, only execution can be stayed. Now, you have not challenged the,
No, because while we filed this appeal, we are not come to the knowledge that execution proceeding has been filed. They have filed the execution case in the year of 2022 when the municip has decreed the will. When I filed the appeal, that execution proceeding not brought on record. Then, well, after this,
okay, let them file a written objection.
in the meantime, relief, my lord. The loss of Kali page 57.
No, you
57.
tell me
Yes.
what relief you prayed for.
We sought some relief, my lord.
That is what I am asking.
Suite of offences be dismissed with cause, number one. Suite of plaintiff be dismissed with cause, number two, the compensatory cost census awarded. That the decree for declaration that the defendant number 1 and 8 have right title, interest and confirmation position over schedule Y and Z schedule land for the counterclaim. A decree for partition Y to Z schedule land of counterclaim in favor of the defendant number 1 and against the plaintiff. That the cost of the suit land, the counterclaim be decreed in favor of the main defendant. Here in this case, my lord, they
And what was the relief prayed for by the plaintiff?
For declaration of right title, interest
and
in respect of
recovery of
as a-
possession.
and recovery of possessions. And it is partition was also
Your suit was decreed
decreed.
and the counterclaim was dismissed. He has filed an appeal against only
Against
counterclaim.
the counterclaim that reflects in page 7, ma'am.
not against the counterclaim as a whole. As a whole, appeal has been filed. Now, loss of file kindly see, loss of file admitted appeal
Lordship kindly see, our specific case is that we purchase the land, that when the respondent plaintiff, he sell the land, the sell deed is there. We are in possession, but they file a suit without declaration of the cancellation of that sell deed, my lord. She clearly admitted, yes, she put signatures.
Now, whether you have
Lordship kindly see.
whether you have challenged the decree,
Page 7, my lord, your lordship kindly,
page 7 of the
memo of appeal. Para 1. Against the
appeal was preferred only against
counterclaim.
dismissal of the counterclaim. Where is your memo of appeal? You have not challenged the
Decree of the plaintiff.
decree in favor of the respondent,
Before the
first appellate court.
But generally, my lord, that is there, but if you lost the kindly see that degree also, my counterclaim, my lord. So far as my counterclaim is concerned, I purchased the land by registered sale deed, they executed the sale deed in my
You could have challenged. You are only making submission that they have not challenged the sale deed. Now,
my lord.
Therefore, it appears that this is not a case for stay.
My lord, the loss of kindly see. That suppose, my lord, my counterclaim is allowed.
Yes.
Yeah.
Suppose the
My
no, I am helping you. Suppose the execution is completed. The land is given in possession to the respondent, and your second appeal is allowed.
Yes.
Then there are provisions under 144. You have to come under 144.
Yes.
That is the option available to you. But mere possibility of a favorable order in the RSA without any challenge to the decree which is put into execution, you cannot pray for staying.
My lord, Roshan kindly see, in this case, their judge degree, my lord. My lord, their degree also.
I'll not go into merit without your challenge to the. Had you challenged the decree, then this court would have gone into merit. But there is no challenge to that decree. Why should this court go into the merit?
In Roshan kindly say page 7, the bill is preferred under the so judgment and decree dated 27/4/2020, title suite number so also. Passed by the learned civil judge Sunil Barbera, wherein learned court dismissed the counterclaim of the appellant. Number 1, the appeal is therefore preferred on the following grounds. It is there.
Challenge is only against counterclaim.
Hello, he'll also kindly see.
No, should I grant him time to file written objection? Yes.
Let the file. In the meantime, my lord, that.
In the meantime, my lord.
Or should I dismiss it today?
Second time, I have no question.
This is not a case for stay. Yes, what is your submission?
My lord. And in page 22 also it is ordered already by the page 22.
say.
Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr.
And N.
M.
N. Hawk.
N. Hawk, learned counsel for the respondent. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant / appellant in connection with regular second appeal number 141/2024. Stop. By this application under Order 41, no, to Koloniki order. By this application, the applicant has prayed for staying the execution of the impugned judgment, staying the execution of the judgment and decree dated 22/3/2024 and 1/4/2024 respectively, passed by learned Civil Judge Borpeta in title appeal number 41/2022, whereby it upheld the judgment and decree dated 27/4/2022, passed by learned Munsif number 1 Borpeta in title suit number 80/2014, whereby the counterclaim preferred by present respondent, wherein amongst other reliefs, the relief of declaration of right title and interest over the suit land and confirmation of possession of this over the suit land in favor of the present applicant was rejected and the counterclaim was dismissed. Stop. What is your submission, Mr. Ahmed?
My submission is, my lord, although they are not challenging the judgment degree passed by the title suit before the first appellate court. So the first appellate court has discussed the matter in both the taking on both the grounds, as well as the degree passed in the title suit, as well as counterclaim. Take together, my lord. The Lordship Calice's judgment, both the issue has been decided. Their title suit as well as counterclaim, both the ground has been decided here by the judgment. It is already mentioned.
Learned counsel for the applicant has submitted that though the first appeal preferred by the present applicant before the first appellate court, that is the Court of Civil Judge, Civil Judge Borpeta, in title appeal number 41/2022, was directed against the dismissal of the counterclaim filed by the present applicant. However, while passing the impugned judgment dated 22/3/2024, the first appellate court
All the issue has been
decided all the issue involved in the suit,
as well as counterclaim.
including all the issue involved in the suit as well as in the counterclaim. Stop. He further submits that as the regular second appeal number 141/2024 filed by the present applicant impugning the judgment dated 22/3/2024 passed in title appeal number 41/2022 has already been admitted and two and once substantial question of law also been formulated by this court on 2/8/2024, the applicant would be highly prejudiced if the decree granted in favor of the respondent by the Court of Learned, Munsif number 1, Borpeta, in title suit number 80/2014 is executed during the pendency of the suit. On the other hand, Learned counsel for the respondent, Mr. N. Hawk, has vehemently opposed the prayer for grant of stay of the execution of the decree granted in favor of the respondent by the trial court, that is the Court of Learned, Munsif number 1, Borpeta, in title suit number 80/2014. He submits that in the aforesaid suit, the petitioner and the present respondent was the plaintiff, and he had prayed for a decree of declaration of right title and interest of the plaintiff/present respondent, as well as for recovery of possession of the suit land. He further submits that the said suit was decreed in favor of the present respondent by the judgment dated 27/4/2022. He further submits that by the said judgment, the counterclaim filed by the present applicant was dismissed. Thereafter, the applicant only preferred the first appeal only against the dismissal of the counterclaim, whereas the judgment by which the suit of the present respondent was decreed in his favor was not put to challenge. Hence, he submits that no case for stay of the execution of the decree which is not put to challenge has been made out by the present applicant. I have considered the submissions made by learned counsel for both sides. Apparently, on perusal of the records, it appears that the decree of declaration of right title and interest in respect of the suit land in favor of the present respondent was passed on 27/4/2022 by the Court of Learned, Munsif number 1, Borpeta, in title suit number 80/2014. By the said judgment, the counterclaim of the present applicant was dismissed. It also appears that though the title appeal number 41/2022 was referred by the present applicant, it was directed only against dismissal of his counterclaim, and the decree granted in favor of the present respondent was not put to challenge. Under aforesaid circumstances, this court is of the considered opinion that no case is made out for grant of stay under Order 41, Rule 5 of the CPC. These the submissions of learned counsel for the applicant that in the event the connected regular second appeal is decided in favor of the present applicant, the decree would become infructuous if stay is not granted. Also is not a convincing submission, as there are sufficient provision in the Code of Civil Procedure to address such a situation. Stop. For the aforesaid reasons, this interlocutory application is dismissed.
Finally, this is over. Finally, this is over.
Finally,
Oh, finally, this was of my.
finally dismissed.
My lord, may I, my lord, I can file challenge the execution stay for the execution case. Now liberty may be granted.
No, I'm not getting you.
Their execution proceeding has been started.
Okay.
So now I can challenge that execution proceeding. My lord. That
No,
liberty-
whatever law provides you, there is no bar.
Yes.
You need no approval from this court.
But
If
because-
there is provision in the law, you can seek that relief.
No, that petition is to be also required to be filed under order 22 rule 4 to stay. 41 rule 4. So that petition also is to be filed as well as by putting this
No,
section.
no, whatever you feel appropriate, you may take that recourse. This court will not make any observation.
Okay.
In what will happen in the
Execution
regular, this RSA,
Service is complete.
it will be fixed for hearing.
Record of title appeal, my lord, that has not been received.
In,
Office note
in
16/10/25.
In RSA number main case, heard Mr. J. Ahmed, learned counsel for the appellant. Also heard Mr. N. Hawk, learned counsel for the respondent. It appears from office note dated 16/10/2025 that though the records of title suit number 80/2014 has been received, the records of title appeal number 41/2022 has not yet been received. Issue reminder for the same. Let this matter be listed for hearing after receipt of the records of the aforesaid case.
Okay.
List accordingly.
Maybe early date may be fixed, my lord. Otherwise,
Let the record come.
25. My lord, that may fix after 3 weeks or 4 weeks. If record come, then not.
No,
that
if
day,
it does not come, you may file
then we'll.
you may file an application for expeditious hearing.
I may be liberty will be granted, my lord, so I can file a petition again under by challenging the execution proceeding.
No liberty is required. There is no bar. What?
May please, your lordship. Lordship, as per office note, the order dated 16/8/25, respondent number 1 and 5 is already has been served.
No way. Putul, record the office note dated
16/8/25, lordship.
There is no such office note. Yes.
Respondent number 2, 3 and 4 is not served for address is not found.
What is to be done?
So, Lordship, I am praying for some time for certain address.
Finding out proper address.
Proper address.
Okay. Heard, Mr. What is your name?
Pegu.
S. Pegu, Learned Counsel for the appellant. On perusal of the office note dated 16/8/2025, it appears that notice is issued to respondent number 2 has returned back with an endorsement within inverted comma, no such person, inverted comma close. And notices issued to respondent number 3 and 4 have been received back with an endorsement. Address could not be found out. In view of the aforesaid office note, the learned counsel for the appellant seeks leave of this court to grant for some time to find out appropriate address of the aforesaid respondent. The prayer is allowed. Let this matter be listed after 3 weeks.
Oblige.
Item 26. May I please your lordship? Lordship, as directed in the last order, the appellant has taken steps on the sole respondent by registered post as well as by usual process of the court. As per the office note dated 15 October 2025, a report from the Jari Karak is received, and the report is tagged as flag number 10, my lord, X, flag X, my lord. In the report of the Jari Karak, it is stated that the Jari Karak visited the address mentioned in the appeal, but he has not been able to find the sole respondent, my lord. However, my lord, we have sent notice in the proper address, my lord, which is also mentioned in the lower court record also, my lord. Today, my lord, I pray for allowing us to serve notice by Dusty, my lord.
Heard. Mr. What is your name?
S. Vikas, my lord.
S. Vikas, learned counsel for the appellant. On perusal of the office note dated 15/10/2025, it appears that notices sent to the sole respondent by usual mode has been returned back without service with a report of the process server to the effect that addressee was not found and the local people failed to identify the name mentioned in the said notice. Stop. It also appears from the office note that the notices sent to the respondent by registered post has not yet been received back by the registry of this court. So, in view of the aforesaid office notes, the learned counsel for the appellant prays for allowing the appellant to take steps for service of notice on the sole respondent by way of Dusty mode. The prayer is allowed. Let the service report in respect of notice issued to the respondent by registered post with AD be further awaited. Stop. The petitioner is allowed to take, the appellant is allowed to take steps for service of notice on the respondent by way of Dusty mode. Stop. In the event of service of notice by Dastimod, the appellant shall submit an affidavit in compliance to that effect on the next date fixed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Highly obliged. 27.
My lordship, notice was issued in this matter and I tried to serve the respondent husband through registered AD. But as per the office note, neither the unserved notice nor the AD has received back yet to this court. So my lordship may grant me time to take fresh steps to serve the respondent.
Heard. What is your
my-
name?
Anindita Deka, but my lordship, one more prayer I would like to make. My lordship, in my petition, I've made a prayer for stay of the proceedings, divorce proceedings of in the Udalguri court. So till the disposal of this pending case,
Where?
in page 12 of this petition.
No, no. Why are you seeking transfer? Which court you are seeking
About
transfer?
the family court. Actually, I am for the petitioner wife. Already 2 cases are pending in Borpeta court and I'm residing in Borpeta. One for domestic violence and one for maintenance. And both
And the
Divorce
divorce case,
the husband has filed in Udalguri court,
where the marriage was performed?
Borpeta.
Okay. Heard Miss Anindita Deka,
Right.
learned counsel for the petitioner on perusal of the office note dated 14/10/2025. It has been stated that it appears that the notice is issued to respondent by way of registered post with AD has not yet returned back. Stop. The petitioner is directed to take fresh steps for issuance of notice on the respondent by speed post within 7 days from the date of this order, returnable on 28th of October,
My lordship, may also mention about the stay part.
returnable on 28th of October. Stop. At what stage it is pending?
It is in the pleading stage, but as per the case status report, it has been listed on 7 November for ex parte hearing. So it will cause prejudice to the wife if any adverse order is passed, if the proceedings are not stayed in the Udalguri, because she is not being able to travel to Udalguri due to financial constraints and some physical difficulties.
Ex parte hearing.
Yes, my lordship, it is as per the case status, yes.
Learned counsel for the petitioner has submitted that the divorce title suit number title suit divorce case number 18/2025 pending before the Court of Learned District Judge Udalguri is fixed on
7th November next.
7 November for ex parte hearing. She submits that the respondent, there are 2 more cases between the present petitioner and respondent. Both the said cases, one under the Protection of Women from Domestic Violence Act,
CGM Court, Borpeta.
is pending before the Court of Learned Chief Judicial Magistrate Borpeta, and another
Or maintenance at the, before
and
the.
another case for maintenance under section 125
Principal Judge Family Court.
of CRPC is pending before the Court of Principal Judge, pending before the Family Court Borpeta. She submits that as 2 of the cases are pending before the courts of competent jurisdiction at Borpeta, and as the marriage between the petitioner and respondent was also conducted at Borpeta, and therefore the courts of Borpeta, courts of competent jurisdiction at Borpeta does have the jurisdiction to try the divorce suit number 18/2025. She prays for stay of further proceeding of title suit within bracket divorce 18/2025 pending before the Court of London District Judge Udalguri within bracket BTR. Stop. Considering the submissions made by learned counsel for the petitioner, this court is of considered opinion that the petitioner would be highly prejudiced if the prayer for stay of the aforesaid divorce suit pending before the Court of London District Judge Udalguri is not allowed at this stage. Stop. Accordingly, comma, in the further proceeding of title suit within bracket divorce number 18/2025 pending before the Court of London District Judge Udalguri BTR is stayed till next returnable date. List accordingly.
A date maybe, I'll get the date from the registry, my lordship. The date.
No. Returnable ki koisa. To 4 weeks. 28th October. List accordingly.
May I please your lordship?
Yes.
Lordship, my senior counsel is looking on court number 24. Kindly pass over the matter for timing.
Okay, we'll take it up after some time.
30.
May I please your lordship? As per office note dated 2/6/2025, service upon the sole respondent is not completed. My lordship will take a fresh step through registered court.
Heard, Mr. What is your name?
JP Boyso.
JP Bush, learned counsel for the petitioner. On perusal of the office note dated 2/6/2025, it appears that the notice issued to respondent has returned without service. Stop. The petitioner is directed to take fresh steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable on 28th of November. List accordingly.
42.
Lordship, as per last office note in the IA number 989, many notices are unserved, Lordship, in case of many respondents. So we will have to take
This
action.
IA is for what purpose?
Delay filing substitution application for respondent number 22.
Then what is the submission?
Lordship, we will have to take fresh steps in many cases, and meanwhile, on the last, as per the last order, 5 more respondents have expired. In that regard, they will have to furnish us as the details so that we can take necessary action, Lord. As per court order dated 8/8/2025.
Heard Miss
S.
S. Todi, learned counsel for the appellants. No, this order is in 989, IA 989. Learned counsel for the appellants. Also Mr. S.K. Sarkar, appearing for respondent number.
There are so many respondents here.
Remaining respondent.
But not all respondents. There are respondent number 1, 6, subclause 3, 4 to 8, 2, 5, likewise. There are so many respondents, but not all. Respondent number 1, respondent number.
Learned counsel for respondent number. You
1.
say the number.
I will write. Lords.
Okay. तुम लिखी ले हुमायूं बाबू. On perusal of the office note dated 14/10/2025, it appears that notices issued to the respondent number 2 within bracket 2 within bracket small a return without service, comma, stop. The notice is issued to respondent number 2 within bracket 3 has been duly served, has been received by his cousin, stop. It is hereby held that notice is issued to respondent number 2 within bracket 3 is duly served. Notice is issued to respondent number 2 within bracket 4, comma 2 within bracket 5, comma 2 within bracket 6 are returned without due service. The petitioner shall take fresh steps for issuance of notice upon the aforesaid respondent by registered post with AD within 7 days of the date of this order, returnable after 4 weeks. Stop. Next para. Notice issued to respondent number 3 and 5.1 are shown to have been served. So stop. It is hereby held that the notice upon the aforesaid respondents within bracket R3, comma R 5.1 bracket close are duly served. 5.1 and 5.3 equally. 5.1 and 5.3. Notices issued to respondent number 5.2 and 5.4 are have returned without due service. The petitioner shall take steps for issuance of notice upon the said respondents by speed post within 7 days from the date of this order, returnable after 4 weeks. Similarly, notice issued to respondent number 7.1, 7, 8, 9, 10 have returned without service. The petitioner is directed to take fresh steps for issuance of notice upon respondent number 7.1, 7, 8, 9 and 10 by speed post within 7 days from the date of this order. Notices issued to respondent number 6.2 and 7.2 are shown to be duly served and therefore they are held to be duly served. Stop. As regards respondent number 6.1, it is reported that said respondent has expired. Stop. Learned counsel for the petitioner seeks praise for allowing the petitioner to take appropriate steps for substitution of the legal heirs of the deceased respondent number 6.1. Prayer is allowed.
Also, as per last order, many more other respondents have also expired. For that also, they will have to furnish us the details, Lordship, so that we can take the necessary action.
To furnish,
We'll furnish.
learned counsel for the respondent undertakes to furnish the details of the legal heirs of all the deceased respondents to the learned counsel for the petitioner within a period of 2 weeks, so that they can take appropriate steps for substituting the legal heirs of the deceased respondent. List accordingly after 4 weeks.
Highly obliged.
Obliged, Lordship.
Next, please, Your Lordship.
Yes.
As per Lozima order dated 16/9 of 2025, Your Lordship, service is completed of all respondents.
16-9.
69,
Heard
25.
Mr. A.R. Karim, learned counsel for the applicants. On perusal of the order dated 16-9-2025 passed by the Lawazima Court, it appears that the notices issued to the service in respect of notices issued to respondent number 1, 2, and 3 is complete. Stop. Therefore, the notices issued to said respondents are held to be duly served. This is condonation. We are giving one more date so that they can appear. List this matter again in the next week on the date to be fixed by registry.
Item 44 and 35. May I please, my lord. My lord, for item number 34, decision IA filed for striking out the respondent number 2 and 3. As my lord, the respondent number 1 already admitted their liability. So the respondent number 2 and 3 is not required in IA number 390 as well as MSC appeal filing number 303/2023. So it may be strike out from the IA number 390/23 and make appeal filing number 303. My lord.
Who is appearing for other side?
My lord, in other side it is not appeared, my lord. So first of all, that is I number 1867 may be allowed. Then after we will take the steps to issue notice to respondent number 3 if the this honorable court may strike out the respondent number 2 and 3, my lord.
2 and 3 in MSC appeal number?
MSC appeal filing number 303/2023. My lord, that is mentioned in item number 35, my lord.
No, this IA is for
striking out item number 34, striking out the respondent number 2 and 3, my lord.
respondent number 2 and 3 in item number?
Item number 35, my lord. That is MSC appeal number 303/23 with IA number 390/2023, my lord.
Where are you presently? In which place? From where you
my
are
lord,
doing your?
My lord, I am in not looking for, my lord.
Okay, okay. Heard Mr. B.R. Das, learned counsel for the applicant. This interlocutory application has been filed 283 some 283. $390. No, sorry. 390. Filed by the applicant, Ms. Shakuntala Sonowal, in connection with IA number 390/2023 whereby the applicant has prayed for striking out the names of the respondent number 2 and 3 in IA number 390. What for this IA number 390 has been filed? For what purpose 390 has been filed? Oh, dead. Lastly, has prayed for the striking out of names of respondent number 2 and 3 in IA number 390/2023, in which the present applicant has prayed for condoning the delay in preferring the connected MAC appeal. Learned counsel for the applicant has submitted that in the aforesaid interlocutory application, the presence of respondent number 2 and 3 may not be necessary. Hence, their names may be strike out. The prayer is allowed. The registry to strike out the names of respondent number 2 and 3 in IA number 390/2023 and list the same after a week. This interlocutory application is accordingly disposed of.
Yes, Mel. Sorry for this. There is some Mahila.
Next item, madam. Next item. Yes.
This interlocutory application file for releasing the 50% of the awarded amount, okay?
For releasing,
Releasing, okay? 50% of awarded amount.
you have any objection? Heard Mr. A. Sharma, learned counsel for the applicant. You are the sole claimant.
No, Lordship, there are two, Lordship. My son and me, Lordship.
Learned counsel for the applicants. Also Ms. S. Mushahari, learned counsel appearing for the respondent opposite, respondent insurance company. This application has been filed by the respondent, by the
I was the claimant, Lordship, in MSC case.
by the claimants / respondent, namely Robin Chandra Saikia and Bhargav Pratim Saikia. Praying for releasing the 50% of the awarded amount deposited by the insurance company before the registry of this court
My check number, Lordship.
in pursuant to the directions of this court while granting stay on the execution of the judgment and award passed in MSC appeal number 393/2022. Learned counsel for the insurance company respondent raises no objection to the prayer made by the applicants. Since the present applicants were the claimant in whose favor the judgment and award which has been impugned in the MSc Appeal number 393/2022 was passed, the prayer is allowed. The registry is directed to release the 50% of the awarded amount which has been deposited by the insurance company before the registry in connection with MSc Appeal number 393/2022 after proper verification and identification of the claimants. This interlocutory application is accordingly disposed of.
Lordship, in the main appeal,
MSc Appeal. Yes.
per order dated 14/5/25, service is complete. It may be fixed for hearing, my lord.
Heard, same naam likhe. No, heard Miss S. Mushahari, learned counsel for the appellant. Also heard Mr. A. Sharma, learned counsel for claimant respondent. It appears from
Order dated.
record that the service of notice on all respondent has been complete, and the records of the concerned motor accident claims case has also been received from the concerned motor accident claims tribunal. This MAC appeal is accordingly ready for hearing. List this matter for hearing after 6 weeks.
Obliged.
Item 39.
I plead your lordship. Probably it is IA for early hearing, lordship. Lordship, the applicants, being the plaintiff, claim their share from the inherited property over which they have legitimate right and are expecting to enjoy the property after partition, lordship, which are at present enjoyed by the defendant respondent.
Who are you? The appellant or
Yes,
the respondent?
plaintiff, lordship.
What is the ground for seeking early hearing?
Lordship, the suit was dismissed by the learned trial court and also by the learned first appellate court, lordship.
Okay. Any stay is operative?
No, lordship.
Heard, Mr. What is your name?
M. Ahmed.
M. Ahmed, learned counsel for the applicant. This interlocutory application has been filed by the appellants seeking expeditious hearing of RSA number 167/2017, which is pending before this court. Stop. Considering the grounds stated in the application, as well as considering the fact that this regular second appeal, that the connected regular second appeal is of the year 2017, and already 8 years have lapsed, the prayer for expeditious hearing is allowed. Let this matter be listed on 13th November 2025 for hearing. This, let the connected RSA be listed for hearing on 13 November. This interlocutory application is accordingly dismissed, is accordingly allowed.
Item 40.
What mention করেছিলেন নাকি? Who is for the applicant? In this matter, an adjournment prayer was made in the morning at the time of mentioning. So we assured the, as you were not present at that point of time,
This matter relates to compensation for land acquisition, and land were acquired in 1991. Compensation was not yet given.
today we are adjourning. He is not present. What is the council's name? A.B. Day. Yes,
An early date may be fixed.
okay. Heard Mr. A.B. Day, learned counsel for the applicant slash appellant who prays for an adjournment. Also heard Mr.
All Oscar. For 1 to 5.
Oscar, learned counsel for respondent number 1 to 5. Also heard Miss N. D.D. Burman, learned senior government advocate, appearing for respondent number 6. Considering the submissions made by learned counsel, the prayer for adjournment is allowed. Let this matter be listed when? In the 3rd week of November on a date to be fixed by registry.
Obliged.
May it be your lord. My lord, here in this matter,
You also made a mention,
yes, your lordship, early in the morning,
yes. What
For-
is your prayer?
for withdrawal, your lordship, of the MC 8 for restoration petition, and one is IA 243 of 2023, condonation of delay. Actually, what happened, your lordship, in this one, CRP, earlier, it was dismissed for non-prosecution. So we prayed for restoration petition. But now I came to learn actually that the matter has been resolved already. So no
Heard
more
Mr.
dispute, nothing, everything is solved.
Heard Mr. A. Narzari,
My name is A. Nazari.
A. Narzari, learned counsel for the applicant. This is in IA 3310. Learned counsel for the applicant has submitted that the applicant prays for allowing him to withdraw the instant interlocutory application as the matter has been amicably resolved between the parties. Considering the submissions made by learned counsel for the
The IA is, sorry for
petitioner,
interruption, your lordship.
this interlocutory application is dismissed on withdrawal.
Your lordship, IA number, withdrawal of IA number 243 of 2023. And another one is withdrawal of this one MC number 8 of 2000. And withdrawal petition is the one which is there, your lordship, the one which I have filed.
This IA 243 is for?
IA 243 is for, your lordship, is for condonation of delay, and MC 8 is for restoration petition. These two has to be withdrawn. And the petition for withdrawal is the one which your lordship was perusing. I recently filed it 2025.
উপরও তো কাটি দিব। In IA 243, heard Mr. A. Narzari, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant interlocutory application on the ground that the matter has been amicably settled between the parties. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This interlocutory application is accordingly disposed of on withdrawal. In next item 8, MC number 8 of same item, MC number 8 of 2023. Different IA. Same order. This case is accordingly disposed on withdrawal.
One more is 243. IA number 243 is there
243. So
for condonation of delay.
243 already I have passed order.
Highly obliged, Your Lordship.
IA number 331.
This is the one which I have
3310.
praying for withdrawal.
Since this application has been filed by the petitioner praying for allowing the petitioner to withdraw the connected IA number 243/2023 and miscellaneous case number 8/2023 in CRPA number in connection with CRP number 76/2020, 76/2019 on the ground that 2014 on the ground that matter has been amicably settled between the parties. The prayer is allowed and this interlocutory application is accordingly disposed of. CRP is already dismissed.
Yes, Your Lordship.
Okay.
Highly obliged.
Item 43.
May it please, Your Lordship. The appellant for Your Lordship, this is an application for condonation of delay. The appellant before Your Lordship is the National Law University and the Judicial Academy. So what had happened, my lord, certain lands were acquired. Now, compensation was assessed by the collector. And thereafter, the persons whose lands were acquired, my lord, they filed a reference before the appropriate authority. And the compensation has been enhanced. My lord, we had entrusted the government counsel to represent us, my lord, but it appears that we were unrepresented, my lord. Now, after receipt of notice from the executing court, but the only remedy left with us before is to approach Your Lordship, my lord. Now, the difficulty that this is a Lordship will issue notice in this claim petition, in the delay condonation. But the difficulty is, my lord, that execution proceedings have started. And if by some means, my lord, the accounts of the National Law University is frozen or, my lord, attached, my lord, will be in great difficulty. Even the university may come to a halt, my lord. Now, under similar circumstances, my lord, because there are several other cases, my lord, in similar circumstances, my lord, this honorable court was pleased to stay further proceeding in the execution cases.
But
while condoning delay, my lord, while issuing notice, my lord.
But before getting this relief of stay,
My lord.
the delay has to be condoned.
Lordship is correct, but there is no bar, my lord.
Wait.
There is no bar, my lord. There is a judgment of our High Court.
What it
Reported in
says?
1997. It says that it is not an absolute bar. In a given circumstances, even the stay may be granted, even when delay is pending.
What it says?
It's a judgment of 1997, 1 GLR 287, my lord.
That stay is granted in which case?
My lord.
Stay will be granted in which case? In
In
court?
stay, my lord, the order copy which I have handed over, my lord, the execution proceeding has been stayed.
No. But in the delay condonation application itself,
My lord.
stay is granted. Yes.
That I understand, my lord, the LA appeal has not been numbered. Because the judgment relies upon a document. If I have to go on the merits, my lord.
No, not on merit.
My-
My simple query is
normally, what your, the answer to your lordship's query is, my lord, that normally, when there is a delay, lordship will not normally stay the proceedings.
Yes.
But it is not an absolute bar.
But
In-
under what circumstances?
Yes, under exceptional circumstances, lordship may stay. Here is a case, my lord, where the functioning of the university may come to a halt. And even otherwise, my lord, the compensation, land acquisition compensation was, for the first time, was paid by the state of Assam, by the judicial department, not by the university.
How much delay is there?
A delay is of 508 days.
And which is the execution proceeding?
Execution proceeding is numbered as 12, my lord.
12 or 25.
12 of 2025. Page.
Where is that?
59, my lord. This is the notice.
Yes, Miss Burman, anything?
On 16, sorry.
The execution has been filed by the beneficiaries whose lands were acquired.
Yes, sir.
Okay. Okay, let us see. Heard. What are the exceptional circumstances when stay can be
That will-
granted?
That will depend on the facts of each case, my lord.
How your case falls within that exceptional circumstance?
Because, my lord, what I am submitting, my lord, that number one, my lord, I am not required to pay the compensation, number one. Because the compensation will
government
be
will-
paid by the government, not by the university. When the land was acquired for the university, the requiring department was the government of Assam in the judicial department.
Then how, why your,
Because I have been made jointly liable, my lord, in the appeal.
so you apprehend that in the execution proceedings, the accounts of the university may
That is
be.
my,
Judicial department is also not made a party, Lordship.
my lord, I have
But
made a party
government,
to the, who were there in the original proceedings, my lord. This is not an original proceeding, my lord, this is an appeal. I have to make only those parties who are party in
State
the
of
reference.
Assam
court.
has been made party.
The state of Assam is the party, is a party, my lord.
State
The
of Assam
collector is there.
represented by collector, Lordship.
Yes.
Collector means, Lordship. State of Assam cannot be represented by collector, Lordship. Yes, Lord.
Heard. Mr. N. Deka, learned counsel for the applicant. Also heard. What is this proviso to section 74?
For condonation of the delay, my lord.
A provision regarding, oh, please read it.
I'm reading 74, my lord. The requiring body or any person aggrieved by the award passed by an authority under section 69 may file an appeal to the High Court within 60 days from the date of award, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 60 days. Every appeal.
Okay. This application under proviso to section 74 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, read with section 5 of the Limitation Act, has been filed by the appellant, that is National Law University and Judicial Academy Assam, praying for condoning the delay of 508 days in preferring the connected land acquisition appeal. Stop. Issue notice to the respondents. Since Ms. D.D. Burman, learned additional senior government advocate, has appeared for respondent number 2 and 3, no formal notice need to be issued to said respondent. However, as regards respondent number 1 is concerned, the petitioner, the applicant shall take steps for issuance of notice upon the said respondent by registered post with AD, by speed post within 7 days from the date of this order, returnable on 28th of November. Learned counsel for petitioner applicant has submitted that in the meanwhile, as the decree holder, that is beneficiary of award, namely respondent number 1, Keshav Kalita, has already filed an execution case which has been registered as money execution case number 12/2025, pending before the Court of London Additional District Judge, Kamrup at Amingaon, or execution of decree obtained by the respondent number 1 in LA reference case number 2/2018 may be stayed. Stop. He submits that unless the decree is stayed, unless the execution of the decree is stayed, the applicant would be highly prejudiced, as in execution of the decree, the accounts of the applicant, which is the National Law University and Judicial Academy, may be frozen. Stop. It is also, stop. I have considered the submissions made by learned counsel for both sides. Though grant of stay of execution in an application for condoning the delay in preferring the appeal is rare before the said condonation, said delay is condoned. However, as the apprehension shown by learned counsel for the petitioners indicates that as the petitioner, as the applicant is a law university where the future of numbers of students will be at stake, this court is inclined to stay the execution of money execution decree 12/2024 till next returnable date. List accordingly on aforesaid date. May 20 list accordingly on 28 November.
I'm okay.
44.
Please lodge. Actually, this is for confirmation of delay. Matter come up for the first time. So this notice may be issued.
Heard Mr. R. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant claimant, praying for condoning the delay of 126 days in preferring the connected MSc appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable after 4 weeks.
In item number 43, Lordship, in this case, Lordship, names of GA Assam shown in the cause list, Lordship.
Your name is not shown, no?
No, Lordship.
In item number 43, as the respondent number 2 and 3 have appeared in this case, the registry is directed to reflect the name of government advocate as engaged counsel for respondent number 2 and 3 in the cause list henceforth.
Obliged.
Item number 45.
May please, my lord, I have appeared on behalf of respondent number 1. Today I have filed the affidavit, my lord. Receipt is available. After showing the cause list, my lord. That is, my lord, I have a objection, my lord, for the limitation because accident is occurred 2018, my lord, and judgment is delivered, my lord, 2025. So 7 years already lapsed for relieve the amount, my lord. And the claimant is the minor boy, my lord. And when his mother was expired, he was reading in student in class 9, my
You will
lord.
be filing written objection.
No, my lord. Today I have appeared only for showing the cause list, my lord. I have not not received a copy of the.
There is no KVL Lordship received for the first time, no, first time
First time.
notice.
But she is appearing.
Appearing on
Yeah.
behalf of respondent number 1, I have filed the column number, my lord. After perusal the cause list, my lord.
There are other respondents also.
Notice go to other respondent.
Heard Mr. K.K. Bhatto, learned counsel for the applicant. Also heard Ms. R.
Kolita, my lord.
Kolita, learned counsel, appears who appears for respondent number 1. This application under section 5 of the Limitation Act has been filed by the applicant, praying for condoning the delay of 44 days in filing the connected MAC appeal. Issue notice to the respondents. Since Ms. R. Kalita has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, the applicant is directed to furnish a copy of application for condonation of delay along with memo of appeal and connected annexures to the learned counsel for respondent number 1. As regards other respondents, the applicant shall take steps for issuance of notice on the said respondents by speed post within a period of 7 days from the date of this order, returnable on 14th of November.
14th November.
List accordingly.
Highly approved.
Timing item 28.
Yes.
Lordship, my senior is still arguing in court number
Now
24.
what is your prayer?
Kindly provide me second date.
We are adjourning it today. Heard, Miss, what is your name?
Yes, Sheikh.
S. Sheikh, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel for the review petitioner is on legs in a different court. The prayer is allowed.
Obliged.
40 of them. I'm sorry, my lord.
No, I have reflected your name.
AB Bay, my lord. Was.
Yes, I have reflected.
Item 46.
Last. It is hearing, but with IA, what for this IA?
Actually, after the hearing, the Honorable Lordship has stayed the further proceeding of the case in the lower court. But the one occasion, the engaged advocate, I have filed one letter of absence on behalf of me. One junior has appeared, but she did not pray before at the time of taking adjournment, and at at the morning hours, she could not pray before the continuation of the stay proceeding.
So for that stay
That is the
proceeding, two IAs are there
one filed by the
for vacation of
respondent
this
for-
stay.
Yes, yes. One for the continuation of
Today
the-
we will finally hear the matter. Yes, what is the matter? Which order you are impugning?
Okay, but prior to the going to the order, that we have to submit some document regarding the
You have to be louder, little bit
yeah,
louder.
Lordship, we have to
Microphone to come করে আসেনি না স্যার check করো.
Lordship, we have to file some document in the our as a additional document prior to the final hearing.
In this
Because-
case,
Yes, yes, in the main case. Because some they have not followed the verdict of the Rajneesh and Sneha Gupta.
no, you are praying for filing additional affidavit.
Yes.
Yes. What is your submission? Yes.
I do not have an objection if he wants to file this thing, any additional document like which he thinks like it's necessary.
When will you file?
3 weeks. 10th of November 26.
Heard Mr.
DK Bordele.
D.K. Bordole, learned counsel for the petitioner, also heard Miss M. Kechi, learned counsel for respondent. Learned counsel for the petitioner submits that though this matter is listed for hearing, however, he may be allowed to bring on record certain documents relevant for consideration of the instant case by filing an additional affidavit. Learned counsel for the respondent does not oppose the prayer, hence the prayer is allowed. Let this matter be listed again on 11th of 10th of November.
May I, your lordship? Lordship, we were just suggesting since this is a matrimonial dispute, mostly to do like this particular matter is with regard to the maintenance.
Okay.
But and it was the wife, that is my party, who has filed the divorce petition. So he was just suggesting like if at all, like I mean say, any chances of like a
Conciliation.
The
Yes, your
mediation center, it can be referred.
Is there any hope of
It is,
where the wife is staying?
wife is staying in Dibrugarh.
both the parties.
Both the parties are staying in Dibrugarh.
Okay. Where will they appear?
Before you, in the meetings.
You are husband or wife?
Yes, I'm a husband.
Your wife. How much maintenance is paying?
It's given per month.
What you are offering?
It is a permanent solution can be arrived at the mediation center because lady has filed a divorce case that was pending.
No, you can offer to your both of you can also discuss.
It can be permanent solution because the other cases also.
Okay, we are fixing it on 10th of November. On next date, you make a proposal as regard possibility. Miss Kechi, learned counsel for respondent, submits that since the dispute involved in this case is a matrimonial dispute and the parties are related to each other as husband and wife, an attempt may be made to arrive at an amicable settlement between the parties.
It would be a joint prayer.
Joint prayer, Ms. Kechi as well as Mr. D.K. Bordole, learned counsel for the petitioner, made a joint submission that since this is a matrimonial dispute, there may be a possible, stop. The prayer, the learned counsel for both the sides are requested to take necessary instructions from their respective parties in regard to the possibility of reaching an amicable settlement and let this court know about the same on the next date fixed. List accordingly.
Deeply obliged.
Highly